And now for something completely different.
Oh, say, I started a show full of fun and unintentional things. DaHoShow, streaming on YouTube for thee. DaHoShow, the courts have compelled me to warn you, it's me you will see. Streaming and gaming and talking and fussing. DaHoShow, it's free. Oh, say, I started a show full of fun and unintentional things. DaHoShow, streaming on YouTube for thee. DaHoShow, the courts have compelled me to warn you, it's me you will see. Streaming and gaming and talking and fussing. DaHoShow, it's free.
We'll hear argument next in Case 21-588, United States versus Texas. General Prelogger.
Mr. Chief Justice, and may it please the Court. Texas designed SB 8 to thwart the supremacy of federal law in open defiance of our constitutional structure. States are free to ask this Court to reconsider its constitutional precedents, but they are not free to place themselves above this Court, nullify the Court's decisions in their borders, and block the judicial review necessary to vindicate federal rights. As this case comes to the Court, there are three principal questions. First, is Texas responsible for this law? Second, can the United States sue to hold Texas to account? And third, is the injunctive relief available? And the answer is yes, down the line. Texas is responsible for the constitutional violation here. It enacted a law that clearly violates this Court's precedents. It designed that law to thwart judicial review by offering bounties to the general public to carry out the state's enforcement function. And it structured those enforcement proceedings to be so burdensome and to threaten such significant liability that they chilled the exercise of the constitutional right altogether. The United States has a manifest sovereign interest in suing to redress this violation. SB 8 is a brazen attack on the coordinate branches of the federal government. It's an attack on the authority of this Court to say what the law is and to have that judgment respected across the 50 states. And it's an attack on Congress's determination that there should be access to pre-enforcement review in federal court to vindicate federal rights. The United States may sue to protect the supremacy of federal law against this attack. Finally, the injunction is a proper response to Texas's unprecedented law. If Texas can nullify Roe and Casey in this manner, then other states could do the same with other constitutional rights or other decisions of this Court that they disfavor. Federal courts are not powerless to craft relief to stop that intolerable threat to our constitutional hierarchy.
General Prelogger, would you spend just a few minutes on the United States interests that gives you a basis for being involved in this suit?
Of course, Justice Thomas. The interest of the United States here is the sovereign interest in ensuring that states cannot flout the supremacy of federal law by enacting a law that's clearly unconstitutional and then through this simple mechanism of outsourcing enforcement authority to the world at large, blocking the traditional mechanisms for judicial review that Congress in Section 1983 and that this Court in Ex parte Young recognized would be vital to securing federal constitutional rights against that kind of law.
Is there any difference between legislation and precedent of this Court as far as the supremacy interest that you have?
I think that if a state structured a law in exactly this manner to try to flout this court's precedents, for example, interpreting statutes, that it would raise that same kind of supremacy concern. But of course here I think that the situation has additional urgency because what Texas has done is taken a constitutional precedent from this court and legislated in direct defiance of that precedent and then tried to, in the words of the interveners, box the judiciary out of the equation and prevent the courts from being able to provide any meaningful form of redress.
You based your involvement quite a bit on DEBS. Can you give me a couple of examples where the United States has taken a similar action based on DEBS?
I'd be happy to. And I want to acknowledge at the outset that we can't point to a case that looks exactly like this one, and that's because there has never been a law exactly like this one. No state has ever sought to challenge the supremacy of federal law and keep the courts out of the equation in quite the same way. But I think that there are relevant principles to distill from the DEBS line of cases. And what the court has said is that the United States cannot come in and seek to intervene in a merely private dispute. It needs to be acting on the basis of the public interest and the public at large. And that further, the subject matter of the suit has to be one that concerns and is entrusted to the care of the nation as a whole and for which the nation owes a duty to her citizens. And this court, in various precedents in the DEBS line, has recognized that that kind of sovereign interest can occur in a variety of circumstances. For example, in the American Bell case, the court recognized that the United States could sue in equity to seek to void a patent that had been obtained by fraud, even though the United States had no reversionary interest or proprietary interest in that patent. It was acting on behalf of the nation as a whole to ensure that there couldn't be an acquisition of a monopoly that was based on fraud in that manner.
Well, actually, what I'm more interested in is, have you done something similar when a constitutional right has been involved? For example, there was much discussion about tort actions that were allowed in states involving Second Amendment rights. I'm sure there were many opportunities in the area of race, particularly during segregation, to do similar things. Do you have any examples, not precedents, but examples of the national government taking part in or playing the exact same role or doing exactly what you're doing in other areas involving constitutional rights?
I don't have examples, but that's because I'm not aware of any circumstance where a state before has sought to prevent access to the ordinary mechanisms for judicial review that
Well, even if
federal
it's not
rights.
exactly the same, when a constitutional right is being frustrated by a state process, have you sought to participate in the manner that you're participating now because the supremacy of a U.S. law or constitutional right is not being respected?
Well, I want to be very clear, Justice Thomas, that we're not asserting here an authority to sue just because the state enacted an unconstitutional law. Ordinarily, that wouldn't present the same grave threat to supremacy because under Section 1983 or Ex parte Young, there would be a swift pre-enforcement remedy in federal court. And so the interest we're asserting here isn't intrinsically tied to the underlying substantive right at issue. It's tied to the fact that the state has structured this scheme in a deliberate attempt to prevent federal courts from doing anything about the constitutional violation. And because a state has never before crafted an enforcement scheme like this, there's not been the kind of situation that would prompt the United States to intervene in this manner.
General Prelogar, could I take you to one of the other questions that you started with? In these extremely unusual, unprecedented circumstances, you said the court is not powerless to craft relief. Well, you heard the last argument, and much of the last argument was all about, like, what would relief look like, and how should we craft relief if relief were appropriate? And there were, is it an injunction against the clerks, or is it an injunction against the state AG, or is it an injunction against fill in the blank? How should we craft relief?
I think the appropriate relief here is the relief that the district court entered. The court enjoined Texas from implementing SB 8 and enforcing it in any manner. And then the court went further to identify all the various stages of the SB 8 enforcement proceedings where that injunction would operate to stop the threat of those enforcement actions that have chilled the exercise of the right. And there were three relevant features. First, the district court said that the injunction would appropriately bind those SB 8 plaintiffs who actually choose to exercise the state's enforcement authority. And so those who actually file suit thereby act in concert or active participation with the state. Second, the district court recognized that in these very unusual circumstances, it was also appropriate to bind the clerks and the judges who are being used as part of the machinery of this apparatus to impose the substantial chilling effect through the SB 8 enforcement actions. And finally, the district court recognized that the injunction would reach on the back end any effort by state officials to enforce those judgments because that too would perpetuate the constitutional violation. So I think we have the model already. It's the injunction the United States obtained in this case, and it's intended to provide full and complete relief against the threat, the grave threat that SB 8 is posing to the supremacy of federal law right now.
And if there's some fear that the law we make about how to craft relief will apply in other cases where it's not so necessary, what would you say, what would you do to ensure that that did not take place, to essentially cabin this kind of relief to the peculiar circumstances of this case?
I think it would be appropriate to cabinet in two ways. First, in recognition that ordinarily it is far more appropriate to enjoin the upstream enforcement agents who would be bringing cases to the court in the first instance. That is the ordinary way that an ex parte Young action proceeds, and if the state had not specifically sought to thwart that mechanism here by outsourcing the enforcement authority to the general public, that kind of injunction would have been appropriate. The problem is that the state has specifically, by delegating to members of the general public this enforcement authority, it specifically made it impossible to determine in advance who is going to become an SB 8 plaintiff, who is going to actually choose to file suit. And I think in that circumstance, injunctive relief that prevents the state court proceedings from going forward is appropriate. And then the second limitation that I think the court could articulate is that this is the rare case where the mere existence or threat of the litigation is itself causing the constitutional harm. It's the flood of SB 8 enforcement suits that could be filed that is chilling the exercise of the constitutional right today. And it's not normally the case in an ordinary suit that the mere prospect that there could be a case filed would create this kind of profound harm and chilling effect on constitutional rights. But that was Texas's intent here. That was its clear purpose, and it's the actual effect, because right now in Texas, that constitutionally protected care is not available.
You know, General, I appreciate your point. Texas, as you say, has done everything it possibly can to try to make it difficult for abortion providers to vindicate their rights under our precedents. I get it. I think it's a forceful argument. But I think we have to be concerned about the implications of the mechanisms that you propose for providing some kind of relief. A lot of your brief and all the other briefs that have been filed against Texas in both of these cases suggest that we should issue a rule that applies just to this case. But that's inconsistent with the rule of law. When we decide a case, the rule that we establish should apply to everybody who's similarly situated. And if you look at the particulars of the enforcement mechanisms, they are unprecedented and they provide cause for concern. And so I'd really like to hear your explanation about why they're appropriate and how they can be limited to this case. Start with the judges. It's unprecedented, and it is contrary to our system of federalism to enjoin a state judge even from hearing a case. When has that been done, and how can that be justified? The judge is a neutral arbiter. The judge is bound to apply the Constitution. How can you enjoin a judge from performing a lawful act, which is the adjudication of a case that is filed before the judge?
Well, I want to be perfectly precise that in our case, the district court enjoined Texas and found that that injunction could properly reach the state court personnel who would be then exercising the state's authority.
Well, Texas is an abstract entity, and an injunction has to apply to people. Yes, there are instances where a state has been enjoined, and what that means is that everybody under the control of, let's say, the state, everybody who has to follow what the state attorney general says has to comply, and the state can pick, can work out the way that would work. But that doesn't apply to state court judges.
Well, I certainly acknowledge, Justice Alito, that an injunction that would bind state court judges is extremely rare. It's not unheard of, and I think in the unprecedented facts of this case, it's appropriate relief.
Well, judges have been enjoined. Let me just interrupt you. Judges have been enjoined from performing unlawful acts, but here the act that they are enjoined from performing is a lawful act. How can that be justified? Let me give you this example. Suppose an action is brought under SB 8 in federal court pursuant to diversity jurisdiction. Let's say a woman sues a doctor who has flown in from another state to perform the abortion. Would the district judge in this case have the authority to enjoin another district judge from even hearing that case?
No, I don't think that the injunction could properly reach the federal system. I don't think that there is any realistic possibility that any of these suits could possibly proceed in federal court, because the distinct feature of SB 8 is that the plaintiffs who are authorized to sue need not have any injury or suffer any harm from the prohibited abortions. And so I think the idea that there would be a proper basis for Article 3 jurisdiction is lacking.
Well, it's certainly possible to think of cases where there would be federal jurisdiction. A woman sues an out-of-state doctor in diversity under SB 8 for physical or emotional harm suffered as a result of the abortion. There's injury in fact, and the amount in controversy could be met. So your answer is one federal judge can't enjoin another federal judge, but a federal judge can enjoin state judges because they're lower creatures. That's the answer?
That is not what I mean to suggest. Here, the injunction runs against Texas, and the state court judges in Texas are being utilized by Texas to effectively create an apparatus that is so lopsided, so procedurally anomalous, and so hostile to constitutionally protected conduct that the mere existence of the suits, no matter how the judges adjudicate them, create the constitutional harm by chilling the conduct. And so we are not suggesting that the judges would do anything other than actually follow federal law here. We think each and every one of these SB 8 suits would inevitably be dismissed because the statute is so clearly unconstitutional, but that doesn't remedy the constitutional harm because the constitutionally protected care isn't being provided in the first place.
General, to achieve this injunction against state courts, do we also have to overrule Ex parte Young, where we said, I'll just quote the relevant bit I've got before me, it's an injunction against a state court would be a violation of the whole scheme of our government. The difference between the power to enjoin an individual from doing certain things and the power to enjoin courts from proceeding in their own way to exercise jurisdiction is plain, and no power to do the latter exists because of the power to do the former. So do we have to overrule at least that aspect of Ex parte Young?
No, Justice Gorsuch. I think that aspect of Ex parte Young has to be read in the context of the court's recognition there and the whole thrust of the opinion that the appropriate relief would run against the enforcement agents themselves. I
understand that, and that was Justice Breyer's point earlier. But Ex parte Young also said this, and I think that's just, am I wrong? How do you reconcile saying you can never enjoin a court with saying you can't hear? Something has to give, doesn't it?
Well, I certainly think that it is not uncommon in equity to have relief that is targeted to prevent a suit in law from proceeding. I acknowledge it's unusual to have that relief run against the judges themselves, and if this court has concerns with that approach, I think that the court could rightly recognize that the remedy here could focus on the clerks engaged in the ministerial task of docketing the cases, and as our injunction does, against the SB 8 plaintiffs who are actually exercising the court's enforcement authority. But I do think think that the court's statement in Ex parte Young has to be read against the backdrop of this court's recognition that there would be otherwise effective relief available. And what we're confronting here is a situation where it's very difficult to find that effective relief by design because Texas designed the law specifically to thwart it.
General, do you agree that there are instances in which no federal forum is available to adjudicate a federal right?
Yes, I do agree that that is sometimes the case.
You also agree that it's sometimes the case that a federal right can only be enforced defensively and not in a pre-enforcement challenge?
Yes, that can be the case.
Can you tell us what are the elements that must be necessary for you to have to seek the kind of equitable relief that you are seeking here? Would it be limited to cases where every single one of the characteristics of SB 8 that you mentioned are present? Must they all be present? And if that is the case, is this really what you're seeking, a rule for one case?
I don't want to suggest that every single feature of SB 8 would necessarily have to be replicated, but I think that the overall inquiry would have to focus on whether the state has deliberately sought to prevent any effective means of judicial review. And here we have it both with respect to federal court. Of course, the state has sought to supplant the traditional 1983 action, Ex parte Young action, but we have it on the back end as well, where the state is trying to purposefully make these SB 8 enforcement proceedings so anomalous, procedurally anomalous, and feature rules that are so stacked in favor of plaintiffs and defendants that the clear purpose and actual effect has been to chill the right. And I think that this is a response to Justice Gorsuch's questions as well, because although it is true that sometimes there's not a federal forum to raise a federal claim, for example, with defamation, it's not the case that in those circumstances the state court proceedings are heavily weighted in favor of the plaintiffs with the evident intent to chill the speech from occurring. And the proof is in how this has actually worked in practice, because defamation actions haven't meant that no speech occurs.
Well, counsel, but we've created a whole substantive law of defamation out of concern for chilling effects. And why on that theory wouldn't we go one step further? For all the reasons you've provided, they're good reasons, and I think Justice Alito's said they're strong arguments. Why wouldn't we do the same thing for that other very vital and important right, or the Second Amendment right, or the right to free exercise of religion? They're all – we don't get to pick and choose among our rights. We're supposed to enforce them all equally. Why does this one get special treatment?
This law is different because it has taken the ordinary state court mechanism that might be an appropriate way to vindicate the rights, whatever they are, and it's purposefully sought to obstruct
But you'd agree that tort laws for defamation have a chilling effect.
Yes, but they have.
And you'd agree that gun control laws also have a chilling effect.
They can, but not in the same way that
And you'd agree as well that
operates.
laws restricting the exercise of religion can have a chilling effect.
I'm not denying, Justice Gorsuch, that those kinds of laws can have some measure of chilling effect on the margins, but they look nothing like this law.
You're not suggesting, General Prelogger, that this right is different, are you? If this exact law were issued by a state that wanted to be hostile to gun rights, your argument would be the same, would it not?
It would be exactly the same, because the threat here is to the supremacy of federal law that's accomplished by trying to cut off the channels of judicial review that Congress recognized in Section 1983 would be vital to vindicating federal rights, whether that's Second Amendment rights or rights to religious liberty, or here the right to abortion.
Well, doesn't matter that it's the abortion right. How about the issue of severability? You want to enjoin every action that's brought under SB 8, even though some of them would not violate Roe or Casey. And I guess the justification for that is that in the abortion context, as we held in the prior whole woman's health case, severability doesn't count. Normally, we pay attention to severability clauses, but I guess when it's abortion, if there's one provision of a statute that's unconstitutional, the whole thing sinks. Is that your position?
Well, our position is that the district court rightly applied this court's decision in Whole Woman's Health versus Hellerstedt and concluded that it would effectively amount to legislative work to walk through SB 8 and try to parse it provision by provision and application by application to determine which applications would be constitutionally permissible.
Well, is that what you want us to do if we find one provision of some massive federal statute unconstitutional down the road? Well, it's too much work to go through them all. We're just going to strike down the whole thing. You want us to do that?
The difference here, I think, that the district court recognized is that it would actually require rewriting the statute to try to reach those lawful applications. And I think in particular in this preliminary injunction posture where the court was acting on an emergency basis, that kind of parsing wasn't necessary. But if this court disagreed, I think all that would show is that the court should confine the injunction to the applications that are unlawful under Casey and Roe and make clear that the only acceptable implementation of this would be with respect to post-viability abortions. And, of course, Texas already separately prohibits post-viability abortions. The providers don't provide them, so I don't think that would have any actual real-world effect.
Can you go back to Justice Thomas's question? Imagine those columns there are filled with the California Civil Code. And let's take out those parts that don't deal with private people. So what we have are property and torts and so forth. And someone in your office says, I've been reading that. Don't ask me why. But I found 19 provisions here that I think are unconstitutional. Let's go bring a case. Now, if we accept your argument, I guess that person has a good point. I'm a little nervous. So far, what you've said to distinguish this one is you said, but here Texas purposely did this. Boy, that raises a whole other set of issues, as you well know. When you say the legislative history counts, okay? But you say, but they're not giving a good forum in the state to test out the constitutionality. And now I think about the California Civil Code or the Procedure Code or 15 other things. I don't know. Is that the test? Have you sat down and thought through what are the implications of the test, or is it that the federal government, no matter who's in charge, without a statute, whatever party, whatever president, can just go and intervene in any case, can bring a federal case whenever they think a state law is affecting private people, is unconstitutional? And if not, what's the test?
No, Justice Breyer. We are not urging a broad authority to bring a suit like this in the circumstances that you identified. And I think that there are two critical distinctions here that separate those circumstances from the ones we confront with SB 8. First, here it is perfectly clear that Congress intended to have a federal court forum for the vindication of this type of claim through Section 1983, and the state is purposefully trying to manipulate it through the delegated enforcement authority and avoid that federal court forum. And second, with respect to the state court proceedings, it's not just that these proceedings, in my estimation, deny a fair forum. It's that by their very design, with respect to each and every procedural and substantive rule, they display open hostility to federal rights and try to prevent any effective forum to get statewide relief, declaring this law in violation of this court's precedents.
Thank you, counsel. I share some of the concerns that have been voiced by my colleagues. You say this case is very narrow, it's rare, it's particularly problematic, but the authority you assert to respond to it is as broad as can be. It's equity. You said we have the authority to sue states under equity, which is a limitless, ill-defined authority. And I just wonder, I know you've been asked this question before, but if you could repeat your answer, what is the limiting principle? When we get another case down the road where it's a different Solicitor General who's making this argument in a different case, what are we going to be able to point to that says, no, you can't invoke that broad equity power, or you can't say just because there's a state statute that is enforced by private parties, which is a very common phenomenon, that you then get to sue the states?
Well, Mr. Chief Justice, the equitable remedy that we're seeking here is not limitless. It is the traditional remedy of enjoining implementation of an unconstitutional law. And the limiting principle that will
Well, it's hardly traditional to get injunctions against judges, injunctions against clerks. injunctions against everybody, right? That's part of the relief you seek, isn't it? Anybody can bring one of these suits, so you're seeking an injunction against the world, right?
No, we're seeking an injunction against those who actually choose to involve themselves in the constitutional violation by filing suit.
Well, so anybody can do that. But anyway, I'm sorry.
It's true. I just wanted to be very clear that the injunction doesn't apply to the potential plaintiffs, only to the actual plaintiffs. But to try to address the concern you've raised, I think that here the limiting principle arises from the way this statute operates to try to deprive any meaningful review anywhere, whether in federal court at the outset, whether in state court on the back end through the enforcement proceedings. And I recognize that this seems like a novel case, and that's because it's a novel law. But we do not think that a recognition here that the United States can intervene to try to protect the supremacy of federal law would open the floodgates in the mine-run situations where a state is simply applying a private right of action through ordinary and fair state court proceedings.
Justice Thomas?
I have no questions.
Justice Breyer? Justice Alito?
As to the potential private plaintiffs, how can they be bound under Rule 65 of the Federal Rules of Civil Procedure? With what party are they acting in concert?
They're acting in concert with the state of Texas, which has created the bounty that incentivizes their conduct and has created the apparatus through the enforcement proceedings that allow them to perpetuate this constitutional violation.
Not with the state, not with any individual who is a party?
That's right. We believe that they act in concert with the state, which is the named defendant here and bound by the injunction.
So would any private plaintiff bringing any common law tort suit be acting in concert with the state under the laws of which that claim is asserted?
No, but there's a world of difference between an ordinary private right of action and the exercise of that kind of private enforcement and what SB 8 contemplates.
No, I understand that, but why is the question whether they're acting in concert with the state any different? Here they're acting in concert with Texas, you say, because they are bringing suit under a Texas law. So if somebody brings suit in Maryland under Maryland defamation law, they're acting in concert with Maryland. Is that right?
No, and we're not suggesting that every private right of action is governed by these same principles. But the key difference here is that the individuals who are SB 8 plaintiffs are actually exercising the state's own enforcement authority. This is not meant to remedy some private harm that those individuals suffered. And I think the best example or illustration of that is that the $10,000 plus bounty that the state has created is only available to the first comer. And so the suggestion that was made earlier by Texas that this could be some redress for personal outrage, I think is inconsistent with how the scheme is structured. This is meant to simply function as a method of encouraging the suits to be filed on the state's behalf. And in that circumstance, we think it can qualify as active concert or participation.
The Texas Constitution requires injury in fact, and this statute, as I understand it, permits an award of actual damages in addition to the liquidated damages. And there's nothing particularly unusual about a statute that provides for liquidated damages. So I don't understand your answer at all.
Well, Justice Alito, if that's what the statute was attempting to accomplish, then presumably it would apply those liquidated damages to every single SB 8 plaintiff. It wouldn't limit it to just the first person who is able to effectively bring to bear the coercive force of the state's enforcement authority. And so the suggestion here that the $10,000 is meant to provide a presumptive dollar amount on personal injury, I think is inconsistent with how the statute operates.
All right, so one final question. The federal rules do provide a mechanism for you to do what I gather you're trying to do with respect to these potential private plaintiffs, and that is to certify a defendant class. Did you try to do that? Have you satisfied the requirements of Rule 23 to do that?
We did not try to do that, and again, I think this relates to my answer to the Chief Justice that the injunction doesn't reach the world at large or every possible person, but anyone, anywhere who is authorized under this law to bring suit. Instead, it's narrowly focused on those individuals who choose affirmatively to exercise the enforcement authority by filing suit.
Mrs. Sotomayor?
What happens to your lawsuit if we were to find that whole women's health is justiciable?
I think that wouldn't retroactively operate to extinguish the sovereign injury that the United States experienced when Texas passed this law and clearly attempted to thwart judicial review at a time when the law was unsettled. But I do think that if this court clarified in Whole Women's Health that the providers can move forward with their suit, and if it forcefully rejected Texas's effort here to stymie that kind of federal court review, then we wouldn't have the same sovereign interest in a future case, because at that point the law would be settled and this attempted circumvention would clearly not work. And so
they can't sue the state the way you can because of sovereign immunity. So one of the big issues for them, and I'm not asking you to litigate their case, but I'm asking for your views of how it affects yours, is who do they sue? They haven't sued like you have all SB 8 plaintiffs who file suit. They've sued a clerk of the court, a judge, and attorney general and other state officials. So how do they get the relief that you're seeking? You've heard Justice Alito say not everybody has been named because the SB 8 plaintiffs have not been named. So how can they be bound?
That's right, Justice Sotomayor, and I think that reflects that the relief that we're seeking is in some respects different than the relief that the providers could obtain in their suit, because they don't have a mechanism to identify or sue the SB 8 plaintiffs. Here, our injunction can rightly reach those plaintiffs because the state of Texas is subject to our suit, and then the plaintiffs can be bound under Rule 65. I think that the providers, therefore, have rightly focused on trying to target the aspect of the enforcement proceedings that create the harm through the filing of the cases in the first place. And I understand that to be the basis of their request that the court recognize their claim as against the clerk class.
Thank you.
Justice Kagan?
Well, is it also possible that in the whole women's health suit, that the AG could stand in for the individual plaintiffs in the way that in your suit, the state essentially stands in for the individual plaintiffs?
I think that is possible, Justice Kagan, and so if this court concluded that the AG of Texas could properly be enjoined here in the provider's suit, then that effectively, I think, would pierce the fiction here that the state has tried to create by delegating the AG's enforcement authority to the world at large, and could rightly try to target that aspect of the enforcement scheme.
Justice Gorsuch?
General, are you aware of a precedent that permits an injunction against all persons in the country, the world, the cosmos who bring suit?
No, Justice Gorsuch.
So
our injunction doesn't do that either.
But you said it against anyone who brings suit, right? So I did include that in my limitation. Am I missing something?
Just to be clear, and I'm sorry if I wasn't clear about this before, we understand the injunction only to bind those individuals who choose to file suit. And
yeah,
so
that's
that,
my
at
question.
that point, they would be
I'm
identifiable.
asking you, counsel, are you aware of any other example of such an injunction?
With that specific term, I can't cite one to you. Again,
not in the history of the United States. You can't identify one for us, right?
In the history of the United States, no state has done what Texas has done here.
And then with respect to those individuals who would be bound, could they, for filing a lawsuit in defiance of it and then maybe filing a discovery request or taking some other action, be held in criminal contempt?
They couldn't be held in contempt without receiving notice and an opportunity to be heard, and so I think that they would have an opportunity.
There's always that opportunity to be heard before criminal contempt proceedings, but could they then be held in criminal contempt, consistent with procedural due process?
Yes, so long as they had notice of the injunction, they could be.
Oh, so if they didn't have notice of injunction, then you're saying contempt is not possible?
That's correct.
Okay. Are you aware of another circumstance where an injunction's been issued where contempt's not possible?
Well, Justice Gorsuch, I think in any circumstance where someone didn't have notice of an injunction, contempt wouldn't be possible. That's really
Is the answer no, counsel? You're not aware of one?
I think that it's actually every injunction operates that way.
Because every other injunction provides notice in advance, and this one doesn't. So this one uniquely alone wouldn't allow for contempt proceedings. Is that your argument?
No, the district court specifically tried to facilitate notice by providing
Counsel, if you could answer my question, please. All right, you're saying that they can be entered without notice. An injunction can be entered out without notice. You're not aware of one prior to that. And I'd just like a straight answer as to whether those individuals in these circumstances could be held in criminal contempt or not.
If they did not have notice of the injunction, then no, they cannot be.
Then is this an advisory opinion saying don't file these things, we'll throw them away, but we have no contempt power to enforce the injunction?
No, because the injunction does appropriately bind Texas, and it does appropriately bind all of those individuals who exercise the state's enforcement authority.
What is an injunction without enforcement power?
There would be enforcement power here, both with respect to the state, with respect to the individuals who have actual notice and file these suits, with respect to the court personnel who would violate the terms of the injunction, and with respect to the enforcement agents at the end of the day who would be enforcing these judgments.
On the Deb's question that the Chief Justice raised, just to press that a little bit further, and an assertion of an equity right here, and I think Justice Thomas alluded to this too, has the United States government ever before asserted this equity right to protect individual rights in any other state, ever?
Well, I want to be clear that the right that we're asserting here is to protect the supremacy of federal law. So
and I'm asking, have you ever done that to defend the supremacy of individual rights in any other situation anywhere in the country in our history?
We have brought suit before. It was a series of cases in, I believe, the 1970s that did not work their way up to this court. The United States urged a broader theory there to be able to sue to vindicate constitutional rights generally, but that's not the argument that we're making here. Instead, we are arguing that the specific thing that gives
Besides that one suit, are you aware of any others?
No, I believe there were 3 suits in that line.
Thank you.
Justice Kavanaugh?
General, in the prior case, the plaintiffs would be the same plaintiffs if it were an ordinary ex parte Young situation. General Stone would be representing a state DA or state executive official. We'd have arguments about the merits, which we're obviously not dealing with today, but it would be the same basic situation. There is an extension of ex parte Young to get to the prior cases we've talked about, and that's an important step that we have to analyze. Your case, by contrast, though, seems, and I'm probably repeating others' questions, just different and irregular and unusual, and we don't know where it goes. And if you could fill in, and maybe this will be repetitive, but you think the U.S. has authority to bring a suit like this against any state law that
violates this court's precedents and tries to shield that violation from any effective judicial review in federal or state court. And I recognize, Justice Kavanaugh, that this is an unusual suit. The United States does not lightly invoke an authority like this to sue a state. The reason we've done it here is because SB 8 is so unprecedented, extraordinary, and extraordinarily dangerous for our constitutional structure. If Texas is correct that it can nullify this court's precedents and it can successfully evade the mechanisms that this court recognized in Ex parte Young and Congress recognized in Section 1983, then no constitutional right is safe. And we think that in this extraordinary circumstance, the United States has a sovereign interest in intervening to protect the supremacy of federal law.
What if our precedent on something in a different area of law altogether was just uncertain? There was an open question about something, and a state wanted to kind of draw a line with respect to the precedent. Would the U.S. have the authority there? Is there something about what you think is the clarity of the violation here that triggers your authority?
If the state structured that hypothetical law in this same way, then we would have the same concern that the state is effectively seeking to take the issue away from the courts. And so you can imagine a circumstance where a right is more unsettled. Imagine, for example, in a pre-Heller circumstance, the right to possess handguns in the home. If D.C. had enacted a law that deputized members of the general public to seek these kinds of suits against that conduct, even before the court had clarified the right, I think that would have raised the same concern that effectively the state is seeking to box the judiciary out of being the final arbiter of constitutional rights. Now, I will say that I think that a state is far less likely to engage in this kind of mechanism with an unsettled right because it would think that its law is constitutional, and I would assume that it would want to forthrightly defend it and get a court ruling that confirms that point. But if a state instead sought to shield the law through this mechanism, it would raise the Supremacy Clause concern.
Thank you.
Justice Barrett?
I just want to follow up briefly on the questions that Justice Kagan and Justice Sotomayor were asking you about what happens to your suit if the plaintiffs in the whole women's health suit prevail. Let's imagine that they do prevail on a theory that the Attorney General has this residuum of authority and that the private parties can be bound as state actors pursuant to Rule 65. You told Justice Sotomayor that then the United States' interests would not dissipate even in that scenario, and I guess I didn't understand that. You phrased it, I think, in the past tense, that wouldn't cure the affront to sovereignty that was already there. But, the force of your argument for equity here is the inadequacy of a remedy at law because of the way that Texas has cut off access to the Ex parte Young remedy. So could you just explain to me why your suit would continue to be live or why there would be an argument in favor of it if Justice Sotomayor's hypothetical were in play?
Yes, of course, Justice Barrett, and I appreciate the chance to clarify. I don't mean to suggest that the suits wouldn't interact with each other with respect to what kind of equitable relief would be appropriate. I understood Justice Sotomayor to be asking me whether our suit is effectively contingent on the whole women's health litigation, and my response was that you have to measure the sovereign injury here at the time the statute was enacted. And when the statute was enacted, it was clear that Texas was seeking to deprive others of having an opportunity to go to federal court for a remedy. The law was unsettled, and it was apparent, and in fact has been the effect, that Texas has succeeded in being able to nullify the right currently while these cases are working their way through the courts. But I do think that if this court provided guidance in whole women's health and made clear that a state cannot succeed with what Texas has attempted to do here, then we wouldn't have that same circumvention concern in the future. But in all candor, the concern is that then a state might seek to legislate around whatever the whole women's health decision says. It might try to tweak its enforcement mechanism in some way to get around that ruling. And I think that what that shows is that when a state attempts to thwart judicial review and creates that possibility that the supremacy of this court's decisions will not be respected, the United States may sue in equity to redress that harm.
So it would be kind of a pile-on injunction, like they would have an injunction against the Attorney General and the private plaintiffs acting, as state actors, and then we would also enjoin, let's say that we didn't want to enjoin the clerks and the entire apparatus of the state. Let's say that we thought you too, in getting an injunction against the state of Texas, could really only obtain one against the executive officials who would enforce the law. You're asking just for the same injunction in your suit, but just acknowledging that the United States has the ability to bring this kind of in re deb suit?
Well, I think that it's important to separate out the question of authority to sue with what kind of relief might be appropriate. So we do think that when we filed this suit, and at that point, of course, there was no relief being provided on the ground in Texas. This law had taken effect, and it had chilled a constitutionally protected right out of existence, that at that point we were authorized to bring suit. The question of what the appropriate remedy would be, I think, is a separate one, and I think it very well could be the case that there would not be a need for duplicative injunctive remedies in both of these cases, but that's a separate and distinct question from whether we could sue in the first place.
Thank you.
Thank you. General Stone, welcome back.
It's been a long time. Thank you again, Mr. Chief Justice, and may it please the Court. The Department of Justice's suit offends the separation of powers by usurping for the executive branch the role Congress plays in determining what cases may be heard and what remedies may be provided in the federal courts. As discussed earlier this morning, no Texas official is a proper defendant in a pre-enforcement challenge to SB 8. The United States cannot cure that problem by naming the state of Texas as a nominal defendant and then asking for relief that runs against the same Texas officials that are inappropriate targets for an injunction under bedrock Article 3 and equitable principles. Moreover, the United States is not a proper plaintiff. It cannot claim a sovereign interest in suing to enforce individual rights under Casey, and the remedy it seeks would be completely foreign to traditional equity. Congress must create such novel remedies if they are to exist at all. and Congress has impliedly rejected giving the United States such relief by providing other avenues to vindicate 14th Amendment rights. Like the petitioners in Whole Women's Health, the United States asks this Court to disregard all of this because it deems SB 8 a novel solution for which a novel problem for which this Court must concoct a novel solution. Even if it were, and it is not, such a request must be directed to Congress. The United States cannot seriously assert that the Constitution requires pre-enforcement federal judicial review. It opposes that result in virtually every other case. This Court should reject its request for a special forum, remedy, and cause of action for this case alone. I welcome the Court's questions.
Is there any instance in which the United States can do what it's doing now that would be acceptable to you? That is, that let's say there is no question whatsoever that a state is defying a national law or a federal law or a constitutional provision, such as, for example, the Second Amendment. Is there any instance in which the United States can step in?
So, Your Honor, I have to first clarify. Are you saying with a cause of action provided by Congress or only in this in re debs style stop?
In re debs.
Your Honor, to the extent that Congress had provided either a proprietary right or had recognized a public harm in the form of a statute, for example, the Interstate Commerce Act, and then also the United States was seeking a traditional form of equitable relief, such as in debs to abate a public nuisance, then it could proceed.
So a very narrow set of cases.
Yes, Your Honor, but some.
A separate question. I'm interested in the cases that are proceeding in state court, and this is a carryover from the first case. What remedies could be provided in those cases if they were allowed to proceed?
Well, an individual could receive, for example, an injunction preventing the bringing of an enforcement action or by bringing a lawsuit by the plaintiff who seeks to do so. Now, of course, as discussed earlier to Justice Barrett, that would only provide relief as against that one individual. But the more important part here is that eventually those sorts of cases be decided on stare decisis grounds by appellate courts, which would prevent follow-on cases to some extent. But in terms of relief, you get declarations basically under the Texas state system. A declaration that an application of SB 8 against an individual, I misspoke earlier with an injunction, I'm sorry, that a declaration that an SB 8 claim by that individual against the protected conduct that someone was raising would violate state law, federal law, whatever the claim might be.
And one final point, why wouldn't, and I think I've alluded to this before and asked this before, why wouldn't these private individuals be considered private attorneys generals? Because so much seems to be, one thing that seems rather implicit on the other side is that they are in effect, if not in designation by law, attorneys generals because they are enforcing a statewide policy. So your argument, again, would be that they are not private attorneys general because, or they are not acting in concert, they're not deputized, they're not agents because they're not subject to the state's control, they don't have access to the state's investigatory resources, the state can't at some point, for example, or take the case over like in a key TAM action, those sorts of answers that I was providing earlier, Justice Thomas. But my answer would run specifically to the lack of control between the state with regards to an SB 8 private plaintiff suit.
Let me think about just a specific example, which was the worst one I could think of for you. Suppose the Governor Falbus, had this model law and said anyone who brings a black child to a white school is subject to, and then we copy the law. There we are. Now, if you were in that situation, which I'm sure you're glad you're not, what? What would you do? I mean, if we uphold this, are we retroactively upholding that?
No, Your Honor. As a matter of fact, for that very specific case, Congress has specifically provided DOJ.
No, this is before Congress. I mean, 57, Congress was no help. I mean, believe me, they did nothing. Or if they did something, I'm unaware of it. And if they did something, I assume it out of the hypothetical.
Fair enough. Fair enough, Your Honor. The answer would be that there would have to be recourse, again, to the state court. I'm assuming this is a state legislature because we're talking about federal court.
This was Arkansas in 1957.
Sure, Your Honor. And that, in fact, that court would be obligated to apply this court's decisions. That's a transparent violation of the 14th Amendment, of course, Your Honor. We have to assume that state court judges...
Yeah, but they didn't. I mean, we have some experience. And most of those cases that came up in that period to this court, the judges were aware of that experience, and they tried to shape the law to avoid it. So is there anything you can think of? I'm getting your answer is no. You cannot think of anything. The only thing we would have to have said then is well, it's up to the state of Arkansas's judges.
The problem, Your Honor, is that the number one answer to your question is the thing you've asked me to assume away, which is the thing Congress has actually done, which is in 42 U.S.C. 2000 C6 specifically provided a cause of action for the United States to maintain a cause of action under the Equal Protection Clause.
Can I give you examples where Congress has it? A state dissatisfied with Heller says anyone who possesses a firearm anywhere is subject to litigation by any private citizen anywhere in the country and gets $1 million bounty. No stare decisis, no nothing. How about in Obergefell imposes SBA-style liability on anyone who officiates, aids, or abets a same-sex wedding? How about dissatisfied with Lawrence versus Texas subjects a private consensual sexual conduct of which it disapproved to the exact same law as SBA 8. How about Griswold? The use and sale of contraception is subject to SBA-style liability. So this is not limited to abortion. That's the point that's been raised. It's limited to any law that a state thinks is dissatisfied with.
Your Honor, I've at no point in the earlier argument or this one asserted that the extent of federal courts or federal court availability turns on the underlying right here. Quite the opposite.
So
I agree with you, it doesn't.
your point is that no matter how much a state intends to chill the exercise of a constitutional right, as the Chief said, imposing $1 million liability for an act, which I think almost any sane person except a couple of billionaires might choose to resist, that does not give anyone a right to a federal forum when the state has deputized every citizen to act on its behalf.
No, Your Honor, it does not create federal jurisdiction as a consequence. I do want, however, in the spirit of the hypotheticals you're delivering, want to return to a point that Justice Barrett made at the end of my friend's previous argument. At a very minimum, to the extent that this court believes it has to somehow alter the ex parte Young fictioner, et cetera, to find a way to allow the plaintiffs in Whole Women's Health to proceed, at a minimum, the United States' case must thereby fail. The United States just conceded up here that whatever interest they had would be purely retrospective, as of course, there being some sort of ability to vindicate the rights that Whole Women's Health and other petitioners are trying to provide. They only seek a preliminary injunction, which is by definition exclusively prospective relief, and they cannot possibly maintain their action any further. It goes exactly one way. If the petitioners in Whole Women's Health have some sort of avenue of relief, then the United States must not, which makes sense given for the extraordinary cause of action that they're trying to bring here. Congress has provided the United States, certainly at times, sometimes with truly extraordinary powers, such as the power of preclearance in the Voting Rights Act, to give one extraordinary example. The United States here would want effectively a follow-on injunction for, in their words, in the event that the state of Texas changed its law or otherwise tried to in a way of uncharitably putting it, if the state of Texas changed its law to comply with this court's law, and yet nonetheless have something like SB8. We have a term for when a state is put into a state where they have to get the federal government's approval before it makes a relevant legal change, and that's called preclearance. That's precisely the kind of injunction my friend on the other side was speaking of. So it can't possibly be the case they'd be entitled to that sort of remedy, just as a matter of course, in the event that whole women's health succeeds or prevails to any extent. That's just one component of the extraordinary expansion. I'm sorry, Justice Kavanaugh, I thought you were going to ask me a question. Just one component of the extraordinary expansion of federal power that the United States is asking for here. Not only are they claiming a brand new sovereign interest, which can be synthesized one of two ways, either in ensuring the vindication of individual rights underneath this court's pronouncements in Casey in substantive due process, or apparently a sovereign right to ensure the expansion of access to the federal courts, because after all, Section 1983 and Congress's various statutes that compose the federal courts, they stand as they stand. Texas understands them as is this court. They stand for what they are. The United States can't possibly have a sovereign interest in extending the application of those doctrines to apply to cases to which they don't, just because they deem this a very important case.
General, if I understand your answer to Justice Sotomayor, it was, well, even if that's a really good question that I don't have an answer to in the other case, I do have an answer to it in this case. And that's fine. That's, here you are, we're in this case now. But I guess I just would like to take you back to the other case and to ask you to answer the question that you said you wanted to avoid for Justice Sotomayor.
I'm sorry, Your Honor. I thought I'd agreed that it doesn't depend on the nature of the right being asserted, and that also we could sort of raise the potential sanction as high as possible, and that wouldn't affect federal court availability. I'm sorry. I thought I'd answered that, but to make my answer expressly clear.
Okay.
The other dimension in which the United States is asking for an extraordinary power is the nature of the remedy they're seeking.
I guess I do want to ask a question about that, though. I mean, if that's right, and we say that, we would live in a very different world from the world we live in today. Essentially, we would be inviting states, all 50 of them, with respect to their unpreferred constitutional rights, to try to nullify the law that this court has laid down as to the content of those rights. I mean, that was something that until this law came along, no state dreamed of doing. And essentially, we would be like, we're open for, you're open for business. There's nothing the Supreme Court can do about it. Guns, same-sex marriage, religious rights, whatever you don't like, go ahead.
Respectfully, Your Honor, I have to disagree with you on 2 points. The first one being the state of Texas hasn't nullified anything. The state of Texas specifically set up in state law a recognition of this court's holdings in Casey, providing an undue burden defense, particularly to recognize that this court's holdings bind state courts in their adjudication. And, of course, the federal constitutional right can and must be made available in those state courts regardless. The second point being, to the extent that we're talking about sort of the extremist hypothetical where it's a $5 billion sanction, and by the way, court is on the moon.
But by the way, this seems a pretty extremist hypothetical actual, I mean, because the actual provisions in this law have prevented every woman in Texas from exercising a constitutional right as declared by this court. That's just not a hypothetical. That's an actual.
That's just not true, Your Honor. There's evidence in the record that estimates that the number of abortions occurring right now in Texas is between 50 and 63%.
I'm sorry. You're exactly right. I should have said every woman in Texas who has not learned and has not made a decision before 6 weeks.
Respectfully, Your Honor, there's a big difference between asserting that a state has structured its courts to defy federal law to completely extinguish a right and saying that a state has codified specifically this court's holdings in the applicable case, and then also to that extent the deterrent effect has caused some diminution of the exercise of that right. That's a very substantial difference, and it's certainly a substantial difference for purposes of the judges of the courts of the states of Texas. So, again, just if I may, to go back to the extraordinary nature of the kind of remedy that the federal government is seeking in this
Just
case.
on the question of the kind of law, HB 1280, which is passed around the same time as I understand it, which is the law that trigger law, so to speak. That has ordinary enforcement mechanisms, as I understand it. Criminal sanction enforced by the state, civil. And if you pair that with this law, it looks like this law was designed to avoid the review that law kind of openly would be available.
No doubt Texas, just like every other state when passing its laws, is well aware of the limits of federal jurisdiction in federal courts. And no doubt Texas crafted its law in part because it wanted to avoid federal pre-enforcement challenges as opposed to having those challenges in state court. I agree, that's an obvious purpose of this law, or one of the obvious ways that this law functions. That having been said, Texas doesn't commit a constitutional wrong by channeling its state court challenges into state court. That is not an independent that's not an independent constitutional obligation that Texas is under. It doesn't have to sort of fly blind as far as the collateral effects of what kinds of challenges it will receive when it decides how to structure a law.
But it does have an obligation to respect people's federal constitutional rights.
Absolutely, Your Honor, and again...
So if it's attempting to stifle those rights, chill their exercise, and keep plaintiffs away from a 1983 action and ex parte Young liability, you say there's nothing wrong with that?
Your Honor, the limits of Section 1983 and ex parte Young's availability, specifically 1983, though Congress could extend ex parte Young, are a matter of Congress. The idea that Texas would design a tort statute or design a form of liability that takes that in mind and then says these claims have to go through the state tort system, the state court system. Texas judges are presumed by this court and by, for that matter, appellate judges in Texas to follow this court's precedents fully and faithfully. Texas does not suppress any substantive right by saying that it prefers to see certain kinds of challenges brought through the state court system. And to the extent that one or more Texas state court judges fail to fully apply and faithfully apply this court's precedents regarding Casey or any other constitutional right, this court is and always is the supreme arbiter of properly presented questions.
The problem they raise, and I'll just have you answer it, is they say this law is designed to avoid all judicial review because the penalties that are imposed for violation are so substantial. And then you combine that with the retroactivity provision that people aren't going to be willing to engage in activity that's prohibited by this law. So there'll be no federal court review up front, no state court review on the back end, which is the exact ex parte Young situation. Put aside the named party, but that's the exact situation. Can you respond to that?
Of course, Your Honor. 2 points. The first one being that the procedural mechanisms, the attorney's fees shifting provision and a preferential venue provision, to the extent that those things would be sufficient to effectively deny someone access to the courts standing on their own, then there are an awful lot of statutes and tort actions that deny access to the courts on their own. I mean, another complaint of my friends on the other side in Holman's Health was regarding the lack of non-mutual collateral estoppel. Well, this court has held that there are certain applications of non-mutual collateral estoppel that violate due process. It's never been a violation of due process to not import that doctrine into a state adjudication system. So I think what we're left with here is the $10,000 potential damages award or actual damages that's doing the chilling. And to the extent that we're
General
talking...
Stone, I think it's the combination of everything. It's the $10,000 and it's everything that Justice Kavanaugh said and it's other provisions behind. And we've had a little experiment here and we've seen what the chilling effect is. Usually in these chilling effect cases, we're kind of guessing. Well, this would sort of chill me. Here we're not guessing. We know exactly what has happened as a result of this law. It has chilled everybody on the ground.
Your Honor, to the extent that we're talking about whether one or more of these procedural mechanisms might itself end up being a burden in the undue burden sense, an individual
Please finish your answer.
Thank you. An individual could themselves raise one of these procedural mechanisms or compliance with them in the state court action and say, this particular fees provision defending this action actually is an undue burden on me because it prevents me from raising my undue burden right itself. Or perhaps, for example, a petition clause or due process clause. There might be other constitutional clauses that would protect an individual who's placed into a situation where the rules of a court itself prevent them from exercising an undue burden right. But still what that wouldn't get you is access to pre-enforcement federal review of the substantive due process right that an action under SB 8 may or may not implicate.
Thank you, counsel. Justice Thomas, anything further? Justice Breyer? Justice Alito?
If some abortions have been chilled, is there any way to determine the degree to which that is the result of the potential for SB 8 suits from the degree to which it is attributable to the fear of liability if Roe or Casey is altered?
I don't think there's a way of being able to disaggregate those, Justice Alito, and undoubtedly individuals engaging in protected conduct that believe the protection might be removed or reasonably believe that. Undoubtedly, there's an extra kind of chill they feel, but that's not attributable to the state or to anyone else for that matter.
Would the issuance of the injunction sought by the United States have any effect on liability for abortions performed after the effective date of this act?
So it wouldn't have prevention of liability. It might stop anyone from filing a lawsuit. But of course, an injunction preventing someone from filing a lawsuit doesn't prevent a state law from being effective in the event they could file in another forum or in some way they're not covered by the injunction, Your Honor.
Well, if the injunction were entered and abortions were performed, would that immunize the abortion providers subsequently from liability?
No, Your Honor. All that would do would be preventing the individuals who had notice of the injunction. First, they'd have to have an opportunity to respond before they were enjoined, but let's skip over all of those injunctive problems. Those individuals would merely not be able to bring SB 8 suits. It wouldn't somehow dissolve in the abstract liability under SB 8 for performing the abortions.
Thank you.
Justice Sotomayor?
No.
Justice King? Gorsuch? Justice Kavanaugh?
Can I just get more clarity about how you think that retroactivity provision works? Are you saying that if an injunction were entered and some clinic performed abortions now that were then legal under current law, but the law changes in the future such that the state could, going forward, restrict abortions at an earlier time, are you saying that the state that could then reach back and retroactively or allow suits that would reach back and retroactively impose liability on entities that were committing lawful acts as of the time?
It would be private plaintiffs again, Your Honor, but of course...
Is that a yes?
Yes, Your Honor, yes.
And is there any limit on that retroactive liability?
There might be, again, I have to hypothesize perhaps a due process claim if it were in some extreme circumstance, but no, there's nothing on the face of SB 8 that would provide it.
And doesn't that play into the chilling effect argument that was being raised, that presumably one of the concerns is even though you would challenge it today and think you would engage in the activity today because you would be confident, you're chilled by the prospect of future changes and then someone reaching back and imposing millions and millions of dollars, right?
Perhaps so, Your Honor, but I think that's...
almost certainly so, right? Millions and millions retroactively imposed, even though the activity was perfectly lawful under all court orders and precedent at the time it was undertaken, right?
Undoubtedly, Your Honor.
Okay.
Justice Barrett?
Just have one question. So we're talking about pre-enforcement review and the chilling effect. So if not available, your position is it's not available in federal court, and you pointed out when you were talking to me before in the last case that in state court it's not available in the ex parte Young sense, in which you could obtain an injunction that would altogether protect you from enforcement activity, but you could on a case-by-case basis obtain an injunction against individual plaintiffs. You pointed out that that might ultimately give you more protection because it would go up the chain and there would be stare decisis effect. What if, in addition to the other procedural obstacles that the law contains here, the legislature also added a provision saying there would be no stare decisis effect of any decision reached by the Texas Supreme Court?
Then, Your Honor, I would assume it would make it even more imperative for one of those cases to be taken up by this court to resolve any questions that were presented there. But that would mean that would be the only final way that you could have binding stare decisis effect.
Thank you.
Thank you, counsel. Mr. Mitchell.
Mr. Chief Justice, and may it please the Court. The interveners intend to sue those who violate Senate Bill 8, but only in response to conduct that falls outside the protections of Roe and Casey. The United States cannot seek or obtain relief that thwarts the enforcement of SB 8 in those situations. The statute contains emphatic severability and saving construction requirements, and courts are obligated to preserve the constitutional applications of statutes to the maximum possible extent. The United States also cannot seek or obtain relief that would prevent private individuals from suing under SB 8, because any such relief would be a flagrant violation of the Due Process Clause. A federal court cannot ban private individuals from petitioning the courts in a case to which they have not been made a party. And a federal court cannot foreclose those individuals from suing under SB 8 when they have been given no opportunity to defend the merits of the lawsuit that they intend to bring. I welcome the Court's questions.
I guess one would be, you've heard the exchanges with General Prelogger about the breadth of the asserted federal right.
Yes.
And she offered some answers to those questions about the limited nature, and I wanted to get your reaction to that.
Yes. And Chief Justice Roberts, as I understand the United States' argument, as they've spelled it out on pages 10 and 20 of their brief, the asserted sovereign interest that they're making under NRA Debs depends entirely on the existence of a congressional enactment, Section 1983, that does not go far enough in the views of the United States. What they're saying with respect to their sovereign interest is that Texas is thwarting Section 1983 and Ex parte Young by enacting a statute that is not subject to pre-enforcement challenge under either of those sources of law. That, to us, is not in any way a sovereign interest under Debs. That's a grievance with Congress, that Congress enacted a law, but Congress's law doesn't go far enough for the United States because Texas has found a gap in this congressionally created remedial scheme that allows its law to escape pre-enforcement judicial review. The proper response in that situation is to go to Congress and ask Congress to amend the remedies that they have set forth, either by abrogating state sovereign immunity or perhaps by enacting the Women's Health Protection Act, which would preempt SB 8 and also abrogate state immunity and give the Attorney General the explicit cause of action. But in no way can equity be invoked to patch up the holes or the perceived holes in a statute that Congress has enacted. The second issue with respect to the sovereign interest that the United States asserts surrounds Ex parte Young, because they claim in their brief that Ex parte Young does not go far enough in authorizing a pre-enforcement challenge. And that, too, runs into the problem of Grupo Mexicano. There is clearly a traditional cause of action in equity for an individual to sue an individual officer that is violating his federally protected rights. But there is no traditional cause of action or remedy in equity that would ever allow a court to enjoin the state judiciary from even hearing a case that has yet to be filed. And Ex parte Young explicitly disclaims any such remedy on page 163 when it says that an injunction against the state court would be a violation of our whole scheme of government. So what
but at the same time, subsequent cases suggest that that language can't be read as broadly as you suggest, Shelley against Kramer, Terry against Adams, some of the others where they've recognized that courts can be viewed as a part of the mechanism of enforcing particular rights.
That's true. But in neither of those cases that Your Honor cited was there an injunction directed at the state judiciary itself. And under Grupo Mexicano, equitable remedies must be limited to those that were traditionally available in equity. And Ex parte Young makes clear that a remedy that would enjoin or restrain a state court or a state judge from even considering a case is not a remedy that was traditionally available in equity. So it's impossible to escape the conclusion that this relief requested by the United States is barred by Grupo Mexicano.
Well, Grupo Mexicano is notoriously cryptic. But Shelley against Kramer, Terry against Adams, they aren't really. I mean, if you look at Justice Frankfurter's opinion in Terry, he says, somewhere, somehow, to some extent, you have to have some participation. That seems like a pretty flexible standard.
Well, again, in Terry against Adams, their cause of action was undisputed. The existence of an Article III case or controversy was undisputed. And those are the two obstacles here that the United States must confront. So the fact that there is case law out there in which relief has been granted in similar situations, involving situations where there was no question of the existence of an Article III case or controversy and no question of the existence of a cause of action, does not give any leverage to the United States' argument here, when the very objection we're making is that they can't bring suit because there's no Article III case or controversy under Muskrat, and on top of that, they can't bring suit because there's no cause of action in equity, because the relief they seek is not relief that is traditionally available.
Well, there is an Article III case or controversy with respect to the clerks, right? It's a direct adversity. The clerks want to file the action, and the plaintiffs don't want them to.
True, but the clerks aren't the named defendants in this lawsuit. Only the state of Texas is. And under Muskrat, you cannot sue the sovereign entity when your complaint is that the sovereign is allowing its courts to adjudicate cases under a statute that you believe to be unconstitutional. It would be no different from the abortion providers suing the United States government because they're allowing SB 8 enforcement lawsuits to be heard under the diversity jurisdiction. There wouldn't be a case or controversy with the United States simply because it's opening its courtroom doors to these claims. What they would have to do is wait for the cases to be filed and then assert their constitutional challenges to the statute in that litigation between the private citizens.
Do you agree, to follow up on the Chief Justice's questions, that state clerks, court clerks, and state judges enforce state law when they entertain private civil suits?
No, I don't believe they can be said to be enforcing state law in those situations.
How do you deal with all the language in Shelley versus Kramer that uses the word enforce?
Because I think in that context, enforcement is coming after a judgment has been entered by the court, and then the judgment is being enforced. But simply adjudicating a case at the outset and simply docketing a complaint, that is not enforcement. And this goes to another problem with the remedy that the United States is seeking with respect to the private individuals. They're asking the court to restrain Texas from adjudicating lawsuits. They want to stop the clerks from docketing the complaints. They want to stop the judges from hearing or presiding over the cases. And then they say that injunction should extend to private individuals under Rule 65D2C. The problem is the private individuals aren't doing any of those things that the state has been enjoined from doing. They're doing something entirely different. They're the ones who are filing the lawsuits. And the state can't file the lawsuit because it's not allowed to file it under the statute, and it therefore can't be enjoined from doing so because an injunction against the state that tells it not to file a lawsuit is enjoining the state from doing something that it never would have done in the first place. So there's another major problem with trying to get private individuals covered by this injunction that the district court laid out. The only conduct that private individuals are engaged in is conduct that the state of Texas is not.
Counsel, a state is an idealized entity. The whole fiction of Ex parte Young, it had to be created because a state qua state can't act. It can only designate people to act for it. And so if the state is designating, whether it's ordinary citizens or the attorney general or its district attorneys, if it's designating those people to act for it, why aren't those people bound by any judgment that says, state, what you're doing is unconstitutional.
They would,
and no agent of yours can enforce this law, whether it's ordinary citizens, the Attorney General, state licensing officials, clerks of court, or, as Shelley recognized, a court system that would enforce a restricted covenant demanding segregation. Why aren't we in exactly that same position?
They would be bound if they can satisfy the test of Rule 65 D2C, which says they have to be acting in active concert.
Why? They are.
No.
Each of them is acting under the directives of the state law. So why aren't they acting like the state when they act?
Justice Sotomayor, I respectfully disagree with that characterization.
I know you disagree,
but
but
I'm going to explain why I disagree with it. The state is not in any way directing the activity. Answer.
Please.
The state is not directing the activity of these private individuals. The state has passed a law that gives them the option to sue, and then it has washed its hands of the matter. So there is no joint participation with the state in their decision.
How is that any different than there being state action when a prosecutor exercises a discriminatory Batson challenge? Or how is there state action when state primary actors exclude races or exclude people from primaries? And we've called that state action, even though the state has just given them the authority to act with no control over what they're going to do.
Right.
So we have recognized that that washing your hands doesn't insulate a state.
With your example on the prosecutor.
Or insulate people from acting on behalf of the state.
Yes. The prosecutor, in your hypothetical, is an employee of the state. He's part of the state government. He's part of the machinery of state. The white primary example is a more difficult question because they were formally established as a private entity.
Are you suggesting that states can hire agents to do unconstitutional acts?
No, they cannot hire agents.
So
No.
How can the state designate a private individual
because
to act on under its laws to violate a person's constitutional rights?
Because there's not an agency relationship here, Justice Sotomayor.
It's saying to it, you under this law, our law, you can act.
I see my time has long expired. May I continue to answer? Or
briefly.
Yes, I'm sorry. Justice Sotomayor, if there were an agency relationship, then Your Honor would be correct. They would be bound by an injunction under the principles of Rule 65. But there's no agency relationship here because the state is statutorily forbidden to enforce the law or have any enforcement role whatsoever. That role is given to private citizens. The state can't have any involvement, so there can't be joint conduct with the state with respect to that particular activity.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Justice Barrett? Thank you, counsel.
Thank you, Your Honors.
Rebuttal?
Thank you, Mr. Chief Justice. I'd like to just make 3 points in rebuttal. And I'd like to begin with the point that I understood General Stone to be making, that if this court ultimately concludes in Whole Women's Health that the providers can sue, that the authority we're claiming here to sue as well is extraordinary or unprecedented. And I think it is important to recognize that when the United States of America filed this suit to try to redress the harm to the supremacy of federal law in Texas, the Whole Women's Health providers had not been able to obtain any effective redress from the courts. The law had been permitted to take effect, and it had immediately had its intended operation of chilling the exercise of constitutionally protected conduct altogether, so that abortions that are protected under Roe and Casey after 6 weeks of pregnancy could not occur at all. And I think that that shows the threat to the supremacy that comes from this attempted design of a law to block access to the judiciary. It may well be, and I hope that this court holds in Whole Women's Health, that the providers can move forward, but that hasn't stopped the harm to the sovereign interest of the United States in the meantime, as Texas has succeeded, while these novel issues worked their way through the courts, in blocking access to care that is protected under this court's precedents. And that leads me to my second point, which is to emphasize the nature of the sovereign interest here. It is in preventing a state from being able to act in direct defiance of this court's precedents and block access to the judicial review that Congress and this court have deemed necessary to vindicate federal rights and to further make it the state court mechanism that might provide some alternative basis for raising those constitutional claims wholly ineffective and unavailable. The final point is to just step back for a moment and think about the startling implications of Texas's argument here. Across the arguments this morning, Texas's position is that no one can sue, not the women whose rights are most directly affected, not the providers who have been chilled in being able to provide those women with care, and not the United States in this suit. They say that federal courts just have no authority under existing law to provide any mechanism to redress that harm. And if that is true, if a state can just take this simple mechanism of taking its enforcement authority and giving it to the general public, backed up with a bounty of $10,000 or $1 million, if they can do that, then no constitutional right is safe. No constitutional decision from this court is safe. That would be an intolerable state of affairs, and it cannot be the law. Our constitutional guarantees cannot be that fragile, and the supremacy of federal law cannot be that easily subject to manipulation. So we would ask this court to hold that the United States can proceed with this action and affirm the preliminary injunction entered by the district court and immediately vacate the stay that the Fifth Circuit entered in this case so that Texas cannot continue to deny women in its borders a right protected by this court's precedents one day longer.
Thank you, counsel. The case is submitted.
Thunder of jets in an open sky, a streak of gray, and a cheerful... A loop, a whirl, and a vertical climb, and once again, you'll know it's time for the adventures of Rocky and Bullwinkle and friends. Starring that supersonic speedster, Rocket J. Squirrel, with his pal Bullwinkle the Moose, and a host of others.
Hurry, Bullwinkle! The show's about to start!
I'm coming as fast as I can.
Wave to the people!
Yay!
Now what are you doing?
Sign an autograph. Let's see. John Smith.
But your name is Bullwinkle.
I know, but that's hard to spell.
We're gonna have a lot of fun. Come on and join us.
Sure, there's always room for one more.
Here on the tree-shaded banks of Lake Dinkawawa lies one of America's great storehouses of knowledge, the Double Dome Institute for Advanced Thinking. You, sir, what is your scholastic background?
Well, I have a BA from Columbia, an MA from Harvard, and a PhD from Caltech.
And I take it you're a professor here?
No, I'm the janitor.
Oh, I see. Well, are you gentlemen members of the faculty?
Faculty? We're the freshman class. A squared, B prime, X plus Y. Upsilon, Omicron, Eta Theta Pi. Contemplate, cerebrate, cogitate, do. Double dome, we love you. Felicitations, felicitations, felicitations.
Yes, Double Dome is a shining jewel in the crown of American scientific wisdom, so you can imagine the consternation and dismay that prevailed when one day...
I say, Armbruster, what's the formula for the isopyridine derivative of benzene?
Don't ask me. I'm busy playing with my piece of string.
Armbruster, are you making sport of me?
Oh, no, I'm making a cat's cradle.
Hotchkiss, I think Armbruster has flipped his scholastic wig.
He certainly has. This is how you make a cat's cradle.
Yes, two of the smartest geniuses at Double Dome were now utterly stupid. That wasn't the end either. for next day at a super-secret missile base not far away.
I think you'll find the inertial guidance cam requires a beryllium alloy, gentlemen.
Beryllium?
Beryllium. B-E...
What is it, Doctor?
I can't spell beryllium.
Oh, that's B-E-R-Y-L-L-I-U-M.
Yes, but how do you make the B?
Soon, panic reigned in the highest circles of the scientific community. And at a top-level meeting in Washington, D.C., an ace investigator was put on the job.
Inspector, somebody somewhere is draining off America's brain power. Do you think you can solve the case?
It's child's play, Professor.
Well, what did you find out?
I found out that you can use a magnifying glass to give people a hot foot.
Oh!
Yes, the detective was now as dumb as the scientist. It seemed that the smarter the investigator, the dumber he became.
That's it, gentlemen. We must start from the opposite direction. We have to find a sleuth with no brain to affect. We need the services of the greatest numbskull in America. And that's...
No. You're getting ahead of the story.
Oh.
Well, the great hunt was on. Government files were ransacked for the names and records of every clodpole, dim bulb, and schnook in the country. Finally, the choice was made.
Gentlemen, upon this one nitwit rests the fate of our entire nation.
And his name?
Bullwinkle Moose, Frostbite Falls, Minnesota.
No.
Now.
You called?
Yeah, here's a letter for you, Bullwinkle.
Wowie!
Why so happy? You don't even know what's in the letter yet.
I know, but look at that stamp, a genuine picture of Lincoln with a beard.
You must be crazy about Lincoln.
No, I'm crazy about beards. What does the letter say?
It's from Washington.
Washington. You suppose he heard I was a Lincoln fan?
Bullwinkle.
I'd be a Washington fan, too, if he had a beard. And Washington needs all the fans it can get this year.
Bullwinkle, this says we have to go to Washington. Washington, D.C.
Oh, then let's.
But it wasn't that easy, for at that moment, a mysterious figure lobbed a live hand grenade at Bullwinkle.
Oh, hey, cut it out. You want to hurt somebody?
Apparently so, and we'll find out who next time in the Brain Drainers or Malice in Wonderland. Well, last time, you remember, some of the top scientific minds in the country reverted to being morons who couldn't add 2 and 2. The smartest investigators in the world were called on to solve the problem, but they, too, wound up as complete stoops. In desperation, the government called on Bullwinkle Moose.
They figured I had nothing to lose.
But it looked as if Bullwinkle might not even get started, for in our last episode, somebody had just tossed a live hand grenade at him.
Well, I'll be doggy. It's a pineapple.
Throw it away, Bullwinkle.
Might as well. It isn't even ripe. Hard as a rock. Whoa! Maybe it was riper than I thought.
Oh, boy. Come on, we better get started before something else happens.
Meanwhile, on the site of the explosion, the smoke was just clearing.
Boris, bad enough. Where are you?
I'm up in a tree.
Boris, did you get blown up by your own grenade again?
No, I'm up here robbing birds' nests.
But why?
It keeps me off the streets, that's why. About 10 feet off.
Oh, we're not starting out this story very well, darling.
Ho, ho, ho. One little setback. Nothing. Moose will never reach Washington, Natasha. I'm going to use tragedy on him.
You mean strategy, darling?
No, tragedy. I'm gonna strategy the rope across the door and fasten the end to trigger of the shotgun. And when Moose comes out the door, what is it? Tragedy. You said it.
But Boris was wrong again, for when Bullwinkle came out, he didn't just trip over the rope, he fell over it.
Boy, a good thing you fell, Bullwinkle. That thing went off right over your head.
Let's look on the bright side, Rock. It missed.
Not quite.
And so, in a little while, Rocky and Bullwinkle were on a train headed for Washington.
Gee, I'm worried, Bullwinkle.
The rating of the show down again?
No.
That's odd.
There have already been 2 attempts on your life.
Yeah, but don't worry. We'll be renewed.
I'm not talking about the Bullwinkle show.
You better. We can use the publicity.
I'm talking about somebody back there trying to get rid of you.
Oh, that. Well, they already missed me twice.
Yeah, but you know the old saying.
You mean everything comes to him who waits?
No, I mean the third time's the charm.
There's another one, too. If at first you don't succeed, try again. For just ahead of the train, Boris was approaching the tracks with a long crowbar.
Boris, to get Moose and Squirrel, you will wreck a whole train.
You can't make an omelet without breaking eggs, Poopsie.
And Boris started to pry up one of the rails. As fate would have it, though, this particular railroad was powered by electricity, and when Boris's crowbar touched the third rail...
Ah!
Hey, Rocky! A feller just went by who was all lit up.
We must be next to the club car.
Oh.
And so our heroes traveled across the country unscathed as Boris continued to light up the landscape.
Well, darling, you failed 3 times in one episode.
I know, it's a new course record.
You look pretty stupid, darling.
On the contrary, Natasha, I never looked brighter.
Meanwhile, our hero's train was pulling to a halt.
So this is Washington.
No, it's McKeesport, PA.
I know, I'm just practicing.
Thank goodness this trip will be over soon.
Little did our friends know that high above them flew a mysterious black airplane, which at that moment dropped its nose and plummeted down directly at their railroad car. Well, who's in that plane? And will it really smash into the train? And if so, will our heroes escape? And if they
And if you don't hurry, it's going to hit us before the episode ends.
Oh, yes. Remember, next time episode, the deadheads are feeling zero. Well, when we left our story last time, things were in terrible shape. Some of the nation's smartest geniuses were turning into complete idiots.
Professor, the public would like to know, what is your theory of ion imbalance in solid-state particles?
Don't bother me now. I'm watching the reruns of Pete and Gladys.
But, Professor, that's the commercial that's on now.
Yes, I know. That's the part I like best.
Within a period of weeks, America's intelligence level sank 14 points, the lowest level since 3 itty fishes. In Washington, there was near panic.
Dr. Flegel, we must have a meeting of the nation's remaining eggheads. Will you attend and act as chairman?
I can't.
Why not?
Mama won't let me cross the street.
In desperation, the government sent for Bullwinkle J. Moose.
And his pal, Rocky.
Oh, yes, of course. Meanwhile, a few miles behind them...
Boris, darling, they got away.
I think maybe I've been working too hard, Natasha. I need a vacation.
What was that?
What was what? What was that?
I heard you bad enough.
Boris, that voice, where is it coming from?
My two-way wrist television?
A two-way wrist television?
I'll show that Dick Tracy.
Amazing.
Not so amazing. Everybody has one.
A two-way television?
A two-way wrist.
So, you want a vacation, eh, bad enough?
Boris, that is the voice of fearless leader.
You were expecting maybe Ellen Font?
I may be able to arrange a permanent vacation for you, bad enough.
Just kidding, fearless leader, old body boy, baby doll. You know me.
Unfortunately, yes.
Ha ha, that's funny. Funny.
It wasn't supposed to be.
Oh.
Now that you have failed on your own, you will put into effect Plan X.
Plan X? Oh, no.
It's an order.
Plan X it is.
Signing off. Auf Wiedersehen.
You said it. You know, Natasha, fearless leader is a lying, cheating, double-crossing, vicious, no-good killer. But someday he'll go too far.
Meanwhile, as our heroes paused briefly at McKeesport, PA, a mysterious airplane flew above their train, then suddenly plunged directly at their railroad car.
Bullwinkle, that plane! It's gonna hit us!
Just because we took the train?
But at that moment, the plane dropped a large cylindrical object and zoomed upward.
Land the lakes, now what?
That must be a bomb. This is the end, Bullwinkle.
According to my watch, we still got 1 minute and 5 seconds.
And so it seemed, for a parachute suddenly popped up from the object, and as it floated down, our heroes heard a familiar voice.
Avast and belay, piped the quartermaster and left the dinghy.
Bullwinkle, that's Captain Peach Fuzz.
He sure looks different.
No, he's inside that escape pod.
And it was true. Outstep, backwards, of course, Captain Peter Wrong Way Peach Fuzz.
Rocky, Bullwinkle, where are you?
Right behind you, Captain.
Oh, don't ever sneak up on me like that.
How come this sudden visit, Captain?
Yeah, and why the pod?
Too many starches, I guess. Oh, the pod! Well, I just had to see you.
About what?
Well, it's all in this memo.
What memo?
Oh, wouldn't you know it? I must have left the memo with the pilot.
Oh, boy.
No, that can't be. I was the pilot.
You were?
Yes. I wonder what happened to the plane after I bailed out.
Hey, I think I know.
What?
It travels in a big loop.
Yeah?
And right now, it's coming down on our head.
Yes, sir. There it comes now. And, oh, good heavens. Well, don't miss our next episode, Free to Go, or Crash on Delivery. While on their way to Washington, our heroes were stopped by Captain Wrongway Peach Fuzz, who had just misplaced his jet plane.
Misplaced nothing. There it is, coming right at us.
Hey, that's right, Bullwinkle.
Yeah, but...
Sure is.
Yeah, but...
You got a pretty sharp eye there, fella.
Yeah, but...
He's right, Bullwinkle.
Will you for the cry I stop agreeing with me and move over? Boy, you fellers almost agreeable yourselves under a tombstone.
But you were right, Bullwinkle.
You sure were.
Yes, sir.
Yep.
Certainly slowed the old show up, didn't we?
And, Captain, you were just about to tell us why you wanted to see us.
Well, let me see if I can find the memo. Ah, here it is.
Why are you tearing it up, Captain?
It's secret, Rocky.
But you tore it up before you read it.
I know, it's top secret.
I'll say it is. Now we'll never even know who it was from.
Sure we will.
Who?
It was from me.
Then why write a memo?
Well, what's the use of knowing a secret if you can't tell somebody?
But you sent the memo to yourself.
I know, it's a secret.
If we come by this station again, I'd like to get off.
Anyway, the memo said you're supposed to come with me to McKeesport, PA for a special job.
Right.
So let's go. I got a map right here.
But, Captain...
We'll pick up native bearers outside of Scranton.
Captain...
There's a friendly farmer near Gettysburg who'll let us stay the night.
He should. We paid his rent for 8 years.
But, Captain...
Then onward toward Wilkes-Barre
Captain! This is McKeesport, PA.
It is?
Look at the sign on the station.
I could have sworn I was landing in Skaneateles.
But why should the government want us to go to McKeesport, PA?
Probably because it's situated at the confluence of the Monongahela and Yongiogany rivers.
Yeah, but what's that got to do with anything?
Nothing, I just like the names. Monongahela, Yongiogany.
But as they walked toward the center of town, the good captain did start to tell why they were there. As you remember, the country was facing intellectual ruin because its brainiest eggheads and double-domes were reverting to being stupid clodpoles and addlepates. For instance, at a Florida missile base...
Ready for launching?
5, 4, 3, 2,
Go on, Professor.
I forgot what comes after 2.
You forgot?
Well, it's hard counting backwards.
But, Professor, what about the launch?
My mama packed it in the brown paper bag.
And in a kindergarten class...
Now, Johnny, what is this?
Doggy.
Good. Susie, what is this? Kitty. Good. Now, Dr. Smallhausen, what is this?
Wait, don't tell me. Could it be maybe a goldfish?
As a result of this strange malady, U.S. brain power was lagging badly. Hartford University had to cancel its commencement when it found that the chancellor had signed all the diplomas with an X.
But, sir, why with an X? It's prettier than a Z.
But what's all this got to do with us being in McKeesport, PA?
Well, I'll tell you, Rocky. It's...
Yes?
It's time for ding-dong school.
And the captain dashed into a nearby television sales room, plunked himself down before a set, and refused to budge.
Bullwinkle, it's happened to Captain Peachfuzz. Whatever it is, he's got it.
You mean he's had it?
Apparently so. Well, does this mean that the boys are stranded permanently in McKeesport, PA?
What a way to die!
Things should be clearer next time in McKeesport on the Prod or the Pennsylvania Poker. While in our last episode, Captain Peachfuzz was about to explain to our heroes just why they were in McKeesport, PA, when suddenly...
It's time for ding-dong school.
That's no reason for being in McKeesport, PA.
Bullwinkle, you don't understand. Captain Peachfuzz has suddenly turned stupid.
That wasn't a turn, more of a slight veer.
Nevertheless, the captain plunked himself down in front of a TV set and couldn't be budged.
But we still don't know why we're here.
Why are any of us here, Rock?
Well, I think there's plenty dirty work afoot around here.
Yeah, must be the coal dust.
Yeah. Come look at these footprints.
Sure enough, a mysterious set of footprints led away from the point where the good captain had succumbed to a case of the galloping dumb.
Let's follow him, Bullwinkle.
Why?
Because the good guys always follow footprints to find the bad guy.
If I was a bad guy, I'd walk on my hands.
Oh, come on.
And the plucky squirrel whipped out a large magnifying glass and began to trace the mysterious prints. Little did he know that they had been made by his old nemesis, Boris Badenov, who at that moment lay in wait with a strange-looking object beside him.
I resent that, darling.
Not you, Natasha. He means the gas gun.
So that's what that object was, a gas gun.
See, Boris, you told him.
Who cares? We got it made now.
What's this all about?
I thought you'd never ask. Come with me. Now we go through the magic of the 4-second cross dissolve to the little country of Pennsylvania.
Little but mean.
Gentlemen, we must find a way to make the name of Pennsylvania feared and hated throughout the world.
Yeah. You said it fearlessly, leader.
But why? Why? Look at it this way. Does Pennsylvania have any raw materials?
No.
Do we make things?
No.
Do we have any art or culture?
No.
What is the only thing we got plenty of?
Nothing.
No. Mean. We have more mean per square inch than other countries have in a square mile.
And so?
So we got to export mean to every other country.
But to do that?
Yes. Pennsylvania will declare war on everybody.
But anybody could beat us.
Yes, besides being mean, we're all cowards.
Tut, tut, gentlemen. Here is the genius of my plan.
Hooray!
Not yet, Gerhardt. I tell you when. We'll declare war on everybody, but we won't tell anybody. Now, Gerhardt.
Hooray!
Now, everybody.
Hooray! And so Pennsylvania set to work to develop a secret weapon to end all secret weapons.
How about this death ray machine, Phyllis Leader?
Let's see. You idiot, it doesn't even phase them.
Thank goodness.
What?
I mean, thank badness. Eventually, though, the ultimate weapon was discovered.
Yes, gentlemen, I call it goof gas.
Goof gas?
Yes, one whiff, you're completely stupid.
Let's test it. Gerhardt, take a sniff.
Smells good.
Now, Gerhardt, do you think I'm the handsomest, kindest man in Pennsylvania?
Of course not. You're a mean, ugly schnook.
Put that man under arrest!
And poor Gerhardt was hauled off to solitary confinement.
My boy, your goof gas is a success. Gerhardt turned into a complete idiot.
But his answer was right, fearless leader. You are a mean, ugly schnook.
Of course, but nobody but an idiot would tell me so.
True. Well, then, what country do we turn into nitwits first?
Let's pick an easy one. The U.S. of A.
Hold it. We can't go on with this.
Why not, Benino? He's too cruel and mean?
No.
It's inhuman?
No.
It's expensive?
Not even that.
Then what?
It's the end of the episode.
And so it is, but we'll reveal the rest of the fiendish plan next time in Hairbrain Boris or the Dumb Bunny. Well, last time we found out why there has been such an epidemic of stupidity in the United States. It seems that Pennsylvania, that mean little country, has attacked us with a secret weapon called goof gas.
Right. One poof, you're a goof.
Yes, for the past several episodes, Boris Badenov has been shooting goof gas at America's leading smart Alex and whiskey.
And so, gentlemen, I have devised a totally new compulsive force to launch our missiles.
Yes. What is it?
It's a rubber band.
Ladies and gentlemen, for my first baritone solo this evening, I would like to sing one of my favorite arias from La Sierra d'Amore. Flee, fly, flee. Wanna hold you tight, I wanna hold you. I wanna die, I wanna die, I wanna die.
Boris, that's terrible.
It's the horrors of war, Natasha.
But now, at this very moment, our heroes are hot on Boris's trail.
This way, Bullwinkle.
Isn't it though?
Little realizing that Boris is really lying in wait for them. So as our heroes rounded the corner...
Take that, moose and squirrel.
Hey, that smells good. Say, Rock, that feller squirted us with perfume.
Perfume nothing. I know what that stuff is.
Aha, the answer to the plot.
And what's more, I know who's doing it.
Pray tell all.
I know where I've heard that voice before.
Wowie! I'll take notes.
The villain of this whole show is named...
Yes.
Gee, I forget.
You forget?
Forget what?
You said you forgot something.
Golly, now I even forgot what I forgot.
Well, won't need the old notebook anymore.
And who are you, stranger?
Stranger? Oh, my stars and garters.
Boris, one more second and Squirrel would have said your name.
Yes, it seems a shame, Natasha.
What?
I could use the publicity.
Why didn't goof gas affect Moose?
Because goof gas affects the brain.
And?
No brain, no effect.
It was true. Bullwinkle's built-in stupidity made him the only living creature immune to goof gas.
A lot of good that does me. I don't have anybody to feed me a straight line anymore.
Tell me about the rabbits, George.
You see what I mean?
Well, Natasha, we stopped those two busybodies cold. Now on to the hardest part of this plan.
And that is?
We're going to take Washington.
Darling, that's not hard.
No.
Look at headline.
Boston takes Washington 7-2.
Anybody can take Washington.
Wait till next year. Come on, Natasha.
And the two villains headed off for our nation's capital. A few days later, they were in the Congressional Visitors Gallery listening to the speeches.
Mr. Chairman, I'm against all foreign aid, especially to places like Hawaii and Alaska.
I demand we increase taxes for everybody under 67.
How old are you?
68.
We've got to get the government out of government.
Well, let's go, Natasha.
Go. You're not going to squirt them with goof gas?
It's too late. Somebody beat us to it.
Then where next?
It's going to be big surprise.
Surprise indeed, for the two no-goodniks were headed straight for...
I said it was going to be surprise.
They were headed straight for...
Now, where are we going?
Gee whiz, now I don't know. Anyway, be with us next time be with us next time anyway. Gee.
Well, at last we found out why America's scientists, professors, and otherwise guys were attacked with a case of the galloping dumbs. It was all the fault of a mean little man from a mean little country.
Go on, say the name.
Pennsylvania.
Not that name, the other name.
Oh, Boris Badenov.
Ta-da!
Yes, armed with a weapon which fired clouds of a strange substance called goof gas, Boris was lowering the nation's IQ in a hurry.
You boys stop playing in that mother. I'll tell your father, the doctor.
Well, that is my father, the doctor.
What's more, in our last episode, Boris even managed to get a shot at Rocky and Bullwinkle. The effect on Rocky was immediate.
Tell me about the rabbits, George.
But the effect on Bullwinkle was negligible.
Didn't bother me much either.
See? Shortly after that, the two villains headed south toward the nation's capital, but found their goof gas of little use.
Mr. Chairman, I propose we set up a $28 million committee to find out why the government is spending so much money.
Boris, what he said. You think he's already had some goof gas?
Natasha, what he said, that is goof gas.
And so the two no-goodniks headed further south toward one of the country's most strategic areas.
Welcome to Cape Carnivorous.
All spies must register with security officer.
Come on.
We're not going to register.
Who's going to spy? We're just going to sabotage.
Halt! Who goes there?
Watch. Hey, Sonny. It's sure nice to see you on the job there. Here's my pass.
But I don't think...
Now stand aside, young man.
Yes, sir, Mr. President.
And the goofy guard allowed Boris and Natasha to enter the top-secret missile base. Be with us next time.
Now, just a minute. This isn't the end.
No, but it won't be long now.
Oh, good heavens. Meanwhile, back in McKeesport, PA...
Rocky, baby, speak to me.
Sure, who are you?
Who am I?
So you're wondering, too?
I'm your pal. Your good ever so best friend.
My best friend?
Yeah, now speak to me.
Hello, Mom.
Mom?
A squirrel's best friend is his mother.
Boy, I never thought I'd wind up as the smart one on this show.
Well, everybody ready to start to work?
Yes, it was Captain Peter Peachfuzz.
Captain, you're back to normal.
Yes, I haven't been there in years either. All those ivy-covered halls.
Where?
At Normal, of course. Waxahachie Normal, my old alma mater.
I mean, you don't have the galloping dumbs anymore.
Oh, those. No, I recovered in about 2 days, Bullwinkle.
2 days? Then that means in a little while Rocky will be back to normal.
I didn't know he was an alumnus.
He's not, he's a squirrel.
And sure enough, at that moment, our little hero shook his head and said...
Hey, I'm back to normal.
Oh, Waxahachie, fair and proud, thy sons and daughters sing out loud.
Hey, what's with Captain Peach Fuzz?
He's back to normal, too.
Our praise for you will never cease. All hail Magenta and Cerise.
But what happened?
We know what happened, so let's see what Boris and Natasha are up to.
We're up to about 75 feet from home plate.
Good heavens, those two miserable loafers are sneaking up on one of our missile launch control centers.
What else? Do you expect us to sneak down?
Well, we'll find out just what devilment they have in mind next time in 5, 4, 3, 2, 1, or the Quick Launch Counter. Well, last time, Boris and Natasha had managed to smuggle their goof gas gun onto one of our secret missile bases.
37% van de OV-medewerkers.
Again, don't know where, don't know when, but I know we'll meet again some sunny day. Keep smiling through, just like you always do, till the blue skies drive the dark clouds far away. So will you please say hello to the folks that I know
Well, it was in my childhood days, oh Lord, many long years ago. Now with the Spirit, now of my Savior, I was filled, Lord, filled, oh, in that old fashioned meeting, oh Lord, our memories, they linger still in that little, oh, that wooden church house out on a hill. You know every Sunday morning, help when we had the family prayer, then to that old country wagon, all would feel, oh Lord, all would feel. Well, we got out on a journey, moving over rocks, God knows and real, to that little, oh, that wooden church house out on a hill. Well, when that old-fashioned preacher, oh Lord, give out the meat to him, then every heart breaks now with the Holy Ghost, oh, would feel, oh Lord, oh, would feel. Well, people, they would be shouting, praise my God, I hear them still, in that little, oh, that wooden church house, out on a hill. Well, it was in my childhood days, oh Lord, many long years ago. Now with the Spirit, now of my Savior, I was filled, Lord, filled, oh, in that old fashioned meeting, oh Lord, our memories, they linger still in that little, oh, that wooden church house out on a hill. You know every Sunday morning, help when we had the family prayer, then to that old country wagon, all would feel, oh Lord, all would feel. Well, we got out on a journey, and preaching. Oh, Lord, give out the me to him. Then every heart breaks now with the Holy Ghost. Oh, would feel, oh Lord, oh, would feel where people, they would be shouting, praise my God, I hear them still in that little, oh, that one church house out on a hill.
conquistar, destrozar, aniquilar, cojo, enfermedades de transmisión sexual. Lo que más me gusta es violar, beber cerveza, hierba y ancianos, porque me gusta verlos correr en llamas.
Jagas punks, och jag gillar att dura superslåss och jag vill dansa sista dansen med dig. Vi är bäst när vi åker i Vepava-turné åt ingen annan jävel ska bråka med oss.
In Virginia, the last time a person was sentenced to death was a decade ago. It was 2011. The last time the state actually carried out an execution, the last time they had, prison staff deliberately, legally kill one of their prisoners, that was 4 years ago in 2017. But this year, in March of this year, there were just 2 men left on death row in that state. And both of them this year had their sentences commuted to life without parole. Both of these men will still spend the eternity of their natural lives behind bars in the custody. Yeah, they got life, but their sentences life. That's because Virginia this year became the 23rd state in the country to formally abolish the death penalty. 23rd state in the country, the first state in the South to do so. And Virginia has a singular history when it comes to killing prisoners. Virginia's history on this goes way, way back. The first public execution in the colonies was in Jamestown, Virginia in 1608. Virginia as a colony and then as a state, as a commonwealth, Virginia has killed more of its prisoners than any other state in the country over its long history. But just this year, earlier this year, they decided they're never going to do that again. They abolished the death penalty. In the past couple of years, Virginia also passed new legal protections for voting rights, leading the nation in some ways in terms of the protection of voting rights. In the past couple of years, Virginia also raised teacher salaries. In the past couple of years, Virginia also expanded pre-kindergarten for little kids in the state. Believe it or not, in the past couple of years, Virginia also passed a package of small ball, but very popular, very enforceable gun reforms. Stuff like requiring a background check for gun sales everywhere, not just for the sales that happen at gun stores. Virginia also, within the last couple of years, provided new protections in law for abortion rights in the state and for women. Happen at gun stores. Virginia also, within the last couple of years, provided new protections in law for abortion rights in the state and for women to be able to. Virginia also, within the last couple of years, provided new protections in law for abortion rights in the state and for women to be able to access contraception. Within the past couple of years, Virginia also, believe it or not, passed a whole slate of criminal justice reforms, including legalizing pot. Virginia also expanded Medicaid, which means that more than 500,000 people in Virginia who didn't have health insurance before, now they have it. 500,000 people. There's only 8.5 million people in the whole state. They just got more than 500,000 of them health insurance. All people who did not have health insurance before. Wow, Virginia, nice to meet you. You've been busy. The reason that has all happened over the last couple of years is because in 2019, Democrats won control of the Virginia legislature, the House and the Senate, for the first time in more than 25 years. They also have a Democratic governor. And so, yeah, they worked on getting people health insurance and protecting voting rights and stopping sending people to jail for pot and all the other things that Democrats have made a priority. All the stuff that they can do something about when they actually hold power. Democrats have been in power in Virginia for the past couple of years. There are 100 seats in the House of Delegates in Virginia, 100 seats. Of the 100 seats, Democrats hold 55 of those seats right now. That's their majority in the House of Delegates. But every single one of those 100 seats in the House of Delegates is up tomorrow. And so if you do the math on that, it means that if Republicans are able to flip 6 seats in the legislature from blue to red, Republicans will take back control of the legislature after Democrats having had the majority for just 2 years. It has been a consequential 2 years in Virginia while Democrats have been in the lead. Republicans are hoping to stop all of that and presumably roll it all back and then some. The vast majority of the Republican candidates who are running for legislative seats tomorrow in Virginia, the vast majority of them are way over on the Trump side of the number line. Many of them are running on how they say the 2020 election was stolen and they want an audit of the election, like the cyber ninjas won in Arizona and all the rest of that. That Trumpiness among the Republican candidates does seem to be giving Democrats a little bit of comfort in terms of their chances tomorrow. I mean, who knows? Virginia is notorious for swinging back in the opposite direction against whichever party won the presidency the previous year. So that means theoretically Democrats have an uphill battle tomorrow in Virginia and Republicans should have an easier time. But Trump did lose to Biden last year in Virginia by more than 10 points. And it would be one thing if the Republicans were running a bunch of like normal Republican candidates, but they're running really Trumpy candidates. And the Trumpier the Republican candidates are who are running to try to flip the legislature, that's probably encouraging for the Democrats' chances. Tomorrow, New York City is going to elect a new mayor. Mayor Bill de Blasio is out. Democrat Eric Adams, you see on the left side of your screen, he is heavily favored to win the New York City mayor's race tomorrow. The Republican candidate in the race, the gentleman in the little red cap on the right side of your race, his name is Curtis Sliwa. He has made his biggest headlines in this campaign when A, he confessed to having a lot of cats. And I mean a lot of cats. And B, he got hit by a cab. He got hit by a taxi cab. He's fine. But, you know, lots of cats and getting run over. While impressive headlines, it is hard to piece that together into a win in a pretty deep blue Democratic city. So Democrat Eric Adams heavily favored to win that New York City mayor's race tomorrow, but we shall see. The great American city of Boston will get a new mayor tomorrow as well. That'll be a really interesting race to watch unfold. The great American city of Atlanta will get a new mayor as of tomorrow, well, as of this month. In Atlanta, it's 14 candidates who are going to be on the ballot, all running to succeed Mayor Keisha Lance Bottoms. Mayor Bottoms decided not to run for re-election, but the practical consequence of 14 candidates running to replace her is that it's going to be hard for any of them to get 50% of the vote. When you've got 14 people on the ballot, nobody's going to get that big a slice. If nobody gets 50% of the vote, the top two candidates from tomorrow's voting will have a runoff in Atlanta on November 30th. The great American city of Buffalo is getting a new mayor tomorrow, maybe. Buffalo has a 4-term incumbent Democratic mayor, a man named Byron Brown. But fascinatingly, he was beaten back in June in the Democratic primary, beaten by a candidate named India Walton. Now, Ms. Walton beating the incumbent mayor in a primary gives her the incredible advantage of her being on the ballot instead of him. But he decided that he wanted to run for re-election anyway. And so now that incumbent mayor is running a write-in candidacy to try to hold on to his seat. If you're looking for a parallel here for this odd situation, it's Lisa Murkowski, the Alaska U.S. Senator back in 2010. Remember? She was the incumbent Republican U.S. Senator. She lost the Republican primary in Alaska, but then she came back in the general election and ran to hold on to her Senate seat as a write-in. Murkowski actually did it back in 2010. That was the first time in more than half a century that a U.S. Senator was elected in a write-in candidacy. But that's what the Buffalo mayor is going to try to pull off tomorrow in that great city. He is trying to pull a Murkowski. We shall see. New Jersey has its governor's race tomorrow. New Jersey generally does not like to re-elect its Democratic governors. Almost all of its Democratic governors, if not all of its modern times Democratic governors, have been single term, I think. But in the case of the incumbent Democratic governor who's there right now, Governor Phil Murphy, the polls suggest that New Jersey may make an exception in his case. They may want him to stick around. We shall see. I will just note that this election in New Jersey, again, between Democratic incumbent Governor Phil Murphy and a Republican challenger named Jack Ciattarelli, because this is a general election in New Jersey, the best ad of the whole election so far is an ad that makes fun of Jack Ciattarelli just as hard for nobody knowing who he is as it does for him being against swearing. They're giving him a hard time here for nobody knowing who he is, nobody recognizing him, nobody remembering how to pronounce his last name. But they're equally giving him a hard time for being against cursing. So I'm gonna play this ad, but this is your fair warning. There are not any actual swear words in the ad. There's a lot of bleeping. But it is unmistakably full of swear words, even the bad ones. So I'm just telling you this in case you're like watching with your 6-year-old and that wouldn't be awesome. Here's your chance to just be distracting for 30 seconds. Okay, here goes.
Do you know who this guy is?
No clue.
No.
That's Jack Ciattarelli, the GOP candidate for governor. He once led an effort to ban swearing.
You're me.
He did what?
No way.
What the Aw, that's kind of nice.
Really?
No.
This is New Jersey.
We can't let that win.
We even extended the bleeps to make it more bleepy. But still, whew, only in New Jersey. Love you, New Jersey. New Jersey and Virginia are the only two states that schedule their governor races every year for the year after a presidential election. Just a quirk of how they schedule things. And that means that there's a lot of outside national attention to those two governor's races every year because they're the only two ones in the country. The New Jersey one is not expected to be a cliffhanger this year. Nobody is expecting the guy who wanted to ban swearing to win in fricking New Jersey, right? But that means that the marquee race for tomorrow really is the Virginia governor's race. And that one deserves all the attention that it's getting. The control of the state legislature there, like I said, is actually a huge deal. Having Democrats lead both houses of the legislature while they've been holding the governorship has just been a huge deal in that state for the past couple of years. It is the House of Delegates, so the House in the state legislature, where every seat is up tomorrow. The Senate actually isn't up tomorrow. That's up in 2023. But if Democrats want to try to hold on to unified control of government so they can keep doing the kind of very consequential policymaking that they've been doing over the past couple of years, they will need to hold on to the House of Delegates, again, which they hold by 5 seats right now. And they'll also need to hold on to the governorship. And that governorship tomorrow that governor's race is turning out to be a good old-fashioned nail-biter. Some of the dynamics from the legislative races are still at play here. As I mentioned, Trump lost to Biden in Virginia in November by more than 10 points. And then the Republicans picked a candidate to run for governor who is endorsed by Trump and who for months wouldn't say whether or not he believed that Biden had actually run the election against Trump. I mean, Trump is doing a tele-rally for Republican Glenn Youngkin tonight in Virginia. Trump has sent out multiple statements just in the past couple of days all about how much he loves Glenn Youngkin and how much he wants all Trumpy people to vote for Glenn Youngkin and how much he and Glenn Youngkin see eye to eye and they want all the same things for the country. Trump and other Glenn Youngkin surrogates are already warning that they expect the race in Virginia is going to be stolen, that the Democrats are definitely stealing it, and I mean, that, of course, lays the groundwork for Republicans to consider the results illegitimate if, in fact, Glenn Youngkin loses, which is the Trumpiest thing of all. One Youngkin rally a few weeks ago, you may recall, featuring Steve Bannon. That rally led with the assembled Glenn Youngkin supporters being asked to pledge allegiance to a flag that they said had been flown at the January 6th attack on the Capitol. That was like the selling point for that flag. That was at the insurrection, so that's the flag they pledged allegiance to. So there's all sorts of ways in which the un-Trumpiness of Virginia, Trump losing Virginia to Biden by more than 10 points, cuts against the strategy here of Republicans having gone with really Trumpy candidates for their legislative seats and a really Trumpy candidate for governor. That said, history favors the Republican candidate for governor in Virginia in a year after a Democrat won the White House. That is generally how it goes. And the polls, which initially showed Democrat Terry McAuliffe ahead, those polls have tightened dramatically in the past couple of weeks to essentially a tie as of a week ago. But since then, some polls even showing Terry McAuliffe now narrowly running behind the Republican Trump-endorsed candidate Glenn Youngkin. So election night's tomorrow. Virginia voters still have one more day to make up their minds. We're going to be here until the wee hours covering it tomorrow night. I'm nervous about that, but we'll be all together. It'll be fine. Even though I'm supposed to be letting him cram/sleep tonight ahead of what's going to be like 24 straight hours of election mania tomorrow, I found myself today, and going through all this data, I found myself sort of unable to resist calling Steve Kornacki and asking him to give us one last election eve assessment of how that race is going and what he's going to be watching for and what we should watch for over the course of the day. Joining us now, blessedly, from his apartment, because he's going to be in front of that darn screen all day long tomorrow, is NBC News national political correspondent Steve Kornacki. Steve, thank you. I don't know if this is beauty sleep time or cram time or what it is, but thank you for letting me interrupt either way.
Appreciate you accommodating me. I know this is not the most professional of backdrops here. Happy to do it.
This is what cable news looks like now, Steve. You'd be surprised. All right. Well, first of all, tell me about, as an election watcher, appreciating the importance of what's going to happen tomorrow, both in terms of the Virginia governor's race and in terms of the control of the legislature. What do you expect the dynamics to be in terms of how this is going to roll out? Is this one of those things where we're expecting, like, Democrats to have done a lot of the early voting, and the early vote is going to be counted first, and so it's going to look blue at the beginning part of the day and red at the later part of the night? Is it going to be that kind of a dynamic?
I think it's going to be a mix. Virginia, the typical pattern in Virginia has been that the Republican areas, the rural areas, are the quickest to count, and you often see the Republican candidates in Virginia getting out to sizable leads in the running tally. In fact, if you look back at 2020 last year when Joe Biden won the state, Joe Biden won it by 10 points, as you said. It wasn't even that close. Biden didn't actually lead the tally until about 11:45 Eastern time on election night 2020. And that's because so much of that Democratic vote is concentrated. You see it right there, the blue of Northern Virginia, right outside Washington, D.C. The biggest of the big counties, Fairfax County, where Biden got 70% of the vote, didn't report really its early or its mail vote until 11:43 Eastern. So that was the reason for the lag there in 2020, if that sort of late arriving Democratic vote. That said, when you talk to the county election administrators here in Virginia, there's some reason to believe it's going to play out differently this year, most notably in the county I was just talking about, Fairfax County. There are some very technical reasons in terms of how the state has asked the counties to compile the vote this year. But the counties basically, when you talk to them, believe that at least a good chunk of that early vote, that mail vote, that absentee vote, is something that they can get out within minutes, potentially, of polls closing at 7 p.m. Some of them think they can get the mail out relatively quickly, first couple hours. Others talk, more of, hey, it might be late at night for that. But Fairfax County is one of those where, in 2020, it was extremely late relative to other counties. This year, they are sending some signals that it could be extremely early.
Steve, obviously, turnout is got a lot of variables that play into it, both because this is an off-year election, but it is a statewide election in Virginia. And we've had so much change in terms of the way people vote, both what ways are available for people to vote, but also what people prefer as their method of voting. And we saw so much of that change around 2020. A lot of those voting methods will carry forward into 2021 in Virginia. Is there any coherent way to look at the number of ballots returned thus far, the patterns that election administrators are seeing at the county level, to know whether this is likely to be a high turnout event?
Yeah, I mean, it's the number and the volume of mail ballots, of absentee, I should say, in-person early votes that have been cast. It's less than 2020. That doesn't surprise anybody. I mean, the turnout was just, as you say, so historic in 2020. It's also substantially more than the last governor's race in Virginia in 2017. And again, back then, the rules weren't quite as expansive as they are now in terms of the availability of early voting. So it's a little tricky in Virginia to know exactly what to compare it to. But the kind of benchmark I've been using in my mind when I look to this is, are they going to run at about 2/3 the total turnout of the 2020 election? That would be about 3 million votes. Is this going to be north of 3 million votes? Is this going to start to get significantly north of 3 million votes? Or is it going to fall? Would it fall short of that? That would be a lower turnout election. So 3 million or so is kind of the benchmark I've set in my head.
Okay. And in terms of key locations and key demographics, you talked a little bit about places to watch, not necessarily bellwethers, but places where the turnout and the vote totals are really going to be potentially determinative in terms of the contest between these two. But both in terms of the governor's race and in terms of the legislative races, I've been thinking a lot about black turnout, and black, largely Democratic turnout has been the answer to everything in terms of understanding Democratic competitiveness in states like Virginia and others. Obviously, white voters in the suburbs turning out to be swing voters has been a very heavily studied dynamic, but it seems like black voter turnout and enthusiasm is as much of the story as anything. Do we have anything that we should be watching for in that regard in terms of that as a key metric? And do you agree that's a key metric?
Yeah, I mean, Virginia is about 20%, 18 to 20% black. That's, I think, what the electorate's expected to be. The closer that is to 20, I think the better news that is for Democrats, the more that drops off from there. I think that the more that you're not, if you're a Democrat, getting quite the turnout you're hoping for, potentially, we will tomorrow night look at that more kind of county by county. I would say, though, in Virginia, too, it is when you look at the big shift that's taken place in Virginia over the last 2 decades and really, really over the last 5 years to get Biden up there to that double-digit lead. It really is. There's just a large number of white voters with college degrees, particularly outside Washington, D.C., particularly outside of Richmond. And you've seen just some massive, massive shifts here over the last couple of elections in these counties. I mean, Loudoun County, which obviously has been in the news a lot. It's there in the sort of Washington, D.C. metro area, more than 400,000 people there. This is a county that just back in 2012, we're talking less than 10 years ago, Mitt Romney only lost it to Barack Obama by about 4 points. Fast forward to 2020, Donald Trump versus Joe Biden. Biden carries it by 25 points. So there's just been some massive movement in the population centers, particularly in Northern Virginia. These are areas that are, there's a lot of that sort of racial diversity, large Asian American population, Latino population as well. But it also is that demographic we talk so much about, kind of trending Democratic nationally. There's an abundance of that, white voters with college degrees, especially in Northern Virginia, also those Richmond suburbs. And that's really, I think, what's powered that shift to Biden winning it by 10.
NBC News national political correspondent Steve Kornacki letting me interrupt his cram/sleep time before a time when I think you're going to be on the air for 24 hours at least. Steve, I apologize for doing this, and I thank you for making time.
Always happy to talk elections. I'll see you tomorrow.
All right. See you tomorrow, Steve. Again, we are going to be having full election night coverage tomorrow night, looking at those key races in the New Jersey governor's race, the Virginia governor's race. The Virginia legislative race is going to be fascinating. We've got key mayor's races in a bunch of important U.S. cities. We've got ballot measures that are going to be super interesting in terms of policy and in terms of the partisan fights around them in states all over the country. It's a more interesting off-year election year than usual this year, and now I'm looking more forward to it than ever. All right. Still ahead tonight, the Supreme Court heard oral arguments today on a case that it went way out of its way for. They have not moved this fast to hear a case since Bush v. Gore. The arguments happened today on this incredibly accelerated time frame. The arguments were live streamed when they happened. They were electric. They were at times pretty infuriating. We've got that story and some expert help to figure it out next.
It's a good day to start something new. To brush away gray in 5 easy minutes. To put yourself out there and always put your best face forward. Just for men, mustache, and beard.
Are you okay?
Oh, it's just a cold.
If you have high blood pressure, a cold is not just a cold. Unlike other cold medicines, Coracetin provides powerful cold relief without raising your blood pressure. Be there for life's best moments with Coracetin, now in sugar-free liquid.
Oh, it looks like we're in a screensaver. We need to go higher. Higher, definitely higher. We're like yodeling high. Yodeling?
No, don't do that.
We should go even higher.
Yeah. I'm good.
Me too.
Adventure has a new look.
Let's go lower. Lower. That's not...
Discover more in the all-new Subaru Outback Wilderness. Love. It's what makes Subaru, Subaru.
Feel stuck with credit card debt?
Lady, would ya?
Move to SoFi and feel what it's like to get your money right.
I jump up on the stage and do my money dance. I throw some money up and watch the money land.
It's time to abort your whole...
Move your high-interest debt to a SoFi personal loan. You could save with low rates and no fees. Earn $10 just for viewing your rate and get your money right.
Get that crap out of
Hearing
here.
is important to living life to the fullest. That's why inside every Miracle Ear store, you'll find a better life. It all starts with the most innovative technology, like the new Miracle Ear Mini, available exclusively at Miracle Ear. So small that no one will see it, but you'll notice the difference. And now, Miracle Ear is offering a 30-day risk-free trial. You can experience better hearing with no obligation. Call 1-800-MIRACLE right now and experience a better life.
With Realtor.com's home alerts, we found our new desert home really fast. And us cacti aren't exactly known for our speed.
Mainly because we don't have legs.
You work with what you have.
Realtor.com, to each their home.
Super Emma just about sleeps in her cape, but when we realized she was battling sensitive skin, we switched to Tide Hygienic Clean Free. It's gentle on her skin and out-cleans our old free detergent. Tide Hygienic Clean Free, hypoallergenic, and safe for sensitive skin.
Meet Tempo, the home gym with a built-in personal trainer. Tempo helps you maximize every workout with custom plans and real-time feedback on your form. Powered by 3D Vision, Tempo is the interactive technology that trains you. With thousands of workouts, including strength training to cardio, yoga, boxing, and more. Get ready to discover what you're truly capable of. Buy now at tempo.fit.
Your website is the core of your business. That's why you need Wix, a fully maintained platform where security and performance are taken care of for you, so you can focus on growing and scaling your business. Monetize your content, create new revenue streams, and generate more sales. Create, manage, and grow your business with Wix.com.
In September, 2 months ago today, the United States Supreme Court allowed the state of Texas to enact a new state law that effectively banned abortion. Now, the Supreme Court precedent Roe v. Wade is supposed to block any state from being allowed to do that, but the conservative majority in the Supreme Court let Texas's ban go into effect anyway. Well, today, on an expedited schedule, the Supreme Court heard oral arguments over 2 challenges to that Texas abortion ban. And the focus for the arguments was how Texas wrote its law specifically to evade the protections of Roe v. Wade. The law is written in such a way that officials who work for the state of Texas aren't actually in charge of enforcing it. Instead, bizarrely, the abortion ban is enforced by individual private citizens anywhere in the country who bring lawsuits, who are allowed to bring lawsuits against anyone who provides a woman an abortion in Texas or helps her get one. Today, the state of Texas argued in the Supreme Court that these challenges against its law should be thrown out. The law should be allowed to stand. And Texas's reasoning for that was because of this vigilante clause. That clause, that enforcement mechanism, makes it so that no federal court should be allowed to challenge something like this. A federal court can block officials who work for a state from doing something, but they can't stop private citizens who have been newly empowered to enforce something as vigilantes on behalf of the state. Federal court can't get involved in stopping that at all. And the Texas Solicitor General in court today admitted that as far as Texas is concerned, they believe that this type of approach need not be limited to laws banning abortion. Any law written with this kind of vigilante enforcement mechanism would also not be allowed to be challenged in federal court. Justice Sonia Sotomayor questioned the Texas Solicitor General on that point today. Justice Elena Kagan followed up on it. And I pulled this piece of the Elena Kagan back and forth with the Texas Solicitor General because I think it is instructive. It is almost explanatory to hear Justice Kagan become exasperated by this line of argument. She has to basically back up after he tries to move on and go, wait. Did you just say what I think you said? Is that really what you're saying? Listen.
I guess I just would like to take you back to the other case and to ask you to answer the question that you said you wanted to avoid for Justice Sotomayor.
I'm sorry, Your Honor. I thought I'd agreed that it doesn't depend on the nature of the right being asserted, and that also we could sort of raise the potential sanction as high as possible, and that wouldn't affect federal court availability. I'm sorry. I thought I'd answered that, but to make my answer expressly clear. Okay. The other dimension in which the United States is asking for an extraordinary power is the nature of the remedy they're seeking.
I guess I do want to ask a question about that, though. I mean, if that's right, and we say that, we would live in a very different world from the world we live in today. Essentially, we would be inviting states, all 50 of them, with respect to their unpreferred constitutional rights, to try to nullify the law that this court has laid down as to the content of those rights. I mean, that was something that until this law came along, no state dreamed of doing. And essentially, we would be like, we're open for, you're open for business. There's nothing the Supreme Court can do about it. Guns, same-sex marriage, religious rights, whatever you don't like, go ahead. By the way, this seems a pretty extremist hypothetical actual, I mean, because the actual provisions in this law have prevented every woman in Texas from exercising a constitutional right as declared by this court. That's just not a hypothetical. That's an actual.
That's just not true, Your Honor. There's evidence in the record that estimates that the number of abortions occurring right now in Texas is between 50 and 63%.
I'm sorry. You're exactly right. I should have said every woman in Texas who has not learned and has not made a decision before 6 weeks.
Respectfully, Your Honor, there's a big difference between asserting that a state has structured its courts to defy federal law to completely extinguish a right and saying that a state has codified specifically this court's holdings in the applicable case, and then also to that extent the deterrent effect has caused some diminution of the exercise of that right.
How dare you say that we've extinguished completely a right? We've simply put it through some diminution. Only women who know they're pregnant and can get to an abortion provider and go through the rigmarole that you need to go through in Texas in order to get an abortion before 6 weeks, if those are the only women who can get abortions now in Texas, it's some diminution of the right. But Justice Kagan there nuts up the implications of allowing this law to go forward, right? Texas has basically set up a system by which they say, you know what, you may think this is a constitutional right, but in Texas, in our state, any person can sue you so that you're not able to access that right. And therefore, your constitutional right is sort of subject to the whims of anybody who might want to sue you to stop you from exercising it. And no, there's no reason that that should be just a constitutional right to get an abortion. It should be a constitutional right to anything. Right, saying basically what Justice Kagan is pointing out there is that any state would get the green light from the Supreme Court here to pass their own Texas-style laws that would allow them to prevent people from exercising not just the constitutional right to an abortion, but any constitutional right. Like she says, guns, same-sex marriage, religious rights, whatever you don't like, go ahead. Under questioning from a different justice today, it was all spelled out. What about if a different state wanted to pay somebody $1 million bounty to bring a lawsuit against someone who sold someone an AR-15? You couldn't, under the Constitution, arguably ban an AR-15, but you could make selling an AR-15 something for which you could be sued and have to pay $1 million. Is that cool? Texas is like, yep, that's cool. It's astonishing. Like I said, the court heard two challenges to the Texas law today. The first was from a clinic that provides abortions in Texas. The second was from the U.S. Justice Department. The Justice Department's case was argued by the brand new Solicitor General of the United States, Elizabeth Prelogar. And because the Justice Department went second, she had the benefit of having the last word today as the justices consider both of these challenges to Texas's ban. Both the Texas Clinic and the Justice Department are asking the court to allow their challenges to the Texas law to go forward, to ignore Texas's claim that, having vigilante random citizens enforce this thing means that this thing is insulated from federal court review. But this is how she closed the arguments today. Listen to her explain to the judges the implications if they side with Texas instead.
The final point is to just step back for a moment and think about the startling implications of Texas's argument here. across the arguments this morning, Texas's position is that no one can sue, not the women whose rights are most directly affected, not the providers who have been chilled in being able to provide those women with care, and not the United States in this suit. They say that federal courts just have no authority under existing law to provide any mechanism to redress that harm. And if that is true, if a state can just take this simple mechanism of taking its enforcement authority and giving it to the general public, backed up with a bounty of $10,000 or $1 million, if they can do that, then no constitutional right is safe. No constitutional decision from this court is safe. That would be an intolerable state of affairs, and it cannot be the law. Our constitutional guarantees cannot be that fragile, and the supremacy of federal law cannot be that easily subject to manipulation. So we would ask this court to hold that the United States can proceed with this action and affirm the preliminary injunction entered by the district court and immediately vacate the stay that the Fifth Circuit entered in this case so that Texas cannot continue to deny women in its borders a right protected by this court's precedents one day longer.
Thank you, counsel. The case is submitted.
The case is submitted. If they can do this, then no constitutional right is safe. No constitutional decision from this court is safe. That would be an intolerable state of affairs. It cannot be the law. Our constitutional guarantees cannot be that fragile. She was sworn in as Solicitor General of the United States on Friday. This was her day at work at the Supreme Court today. Joining us now is our friend Dahlia Lithwick. She is senior editor and legal correspondent for Slate.com. She's the host of their Amicus podcast. Dahlia, it's great to see you. Thank you for being here.
Thanks for having me.
As somebody who knows these cases and the expectations for these arguments like the back of her hand, I just wanted to hear from you today. I know that you were able to listen into the arguments, as we all were. It is amazing to be able to hear them live and in real time as oral arguments, even when we can't be there in person. What did you think?
Well, first off, I just want to point out that summation that you just played by the brand new Solicitor General really ticked off boom, 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 the way she peeled off 3 of the conservative justices today. She mentioned $1 million, the quote unquote bounty that is $10,000. It was Chief Justice John Roberts who brought up the hypothetical. What if it's $1 million? Would that change things? Then she ticked off, what about gun owners? Can you go after them? That was Brett Kavanaugh's concern. And third, she went right to Amy Coney Barrett's concern with this case, which is people cannot effectuate their rights in the Texas state courts if this law is allowed to stand. So she just absolutely masterfully, I think it was a magisterial kind of pulling in all of the doubts of the 3 justices. She only really needed 2 of them, but I think that what you saw right there, what you heard right there, was her being so attuned to the weak spots in Texas's argument and then saying, come sit by me, Justice Kavanaugh, come sit by me, Justice Barrett and the Chief Justice. I think we could get to 5 to strike down this law. It was really a tour de force.
What do you make of the fact that this was heard so quickly by the justices? Does that also tell us anything about how they are inclined? Why do you think they made the decision that they would hear this so quickly? I mean, a 10-day turnaround in terms of getting oral arguments is just unheard of.
Rachel, I've been calling that shadow docket decision that let the law go into effect in September the biggest self-own, a totally unnecessary self-owned by the conservatives on the court. They know that Jackson, the case that's going to be argued 1 month from today on December 1st, could have been the vehicle to erode Roe. Why do it in this sloppy, slapdash way that allows Texas to sort of single-handedly overturn Roe? And so I think what you saw happen was a huge outcry across the country about the shadow docket, how this happened at midnight with a paragraph unsigned order, that women and pregnant people in Texas were suffering outcomes from being denied abortion, and then the polling around the court that just cratered after this. And what you saw, I think, was on a dime, the court saying, maybe we should have heard this. Maybe this should have been argued and briefed, and we should have treated this as though it is a serious constitutional problem. So yes, it was a very short turnaround. The court really calendared this with 10 days to get it briefed and argued. As you said, we haven't seen that since Bush v. Gore, but nothing has changed on the ground, I think, except that the court looks really, really dumb for letting Texas, in effect, make the court look weak and frail. And so that's why I think with 2 months after, the court said, we better hear this as though it's serious, because you know what? It's kind of serious.
Do you think that the quick turnaround in terms of them hearing it means that we'll also have a quick ruling?
I think so. I think we'll have a quick ruling. And let's be really clear, because I think we haven't said it. This is not a decision on the merits. This goes to nothing that has to do with whether Roe and Casey are good law. That's coming in Dobbs. That's coming in a month. But I think for the court to save face, they can at least say maybe Texas shouldn't be allowed to make us look stupid in the future. We'll get to the merits of Roe very, very soon.
Dahlia Lithwick, senior editor and legal correspondent for Slate.com, host of their Amicus podcast. Dahlia, it is fantastic to have you here. Thank you so much.
Thanks, Rachel.
All right, we got much more ahead here tonight. Stay with us.
Tonight, I'll be eating a club sandwich with fries and a side of mayonnaise. Wonderful.
Mayonnaise on fries.
A little judgy, don't you think?
That's weird. So weird.
Oof. I'll also be needing stain remover, club soda, and a roll of paper towels. Lifesaver.
You're weird, man.
To each his own.
My dental health was not good. I had periodontal disease, and I just didn't feel well. But then I found Clear Choice.
Replacing Marcia's teeth with dental implants at Clear Choice was going to afford her that permanent solution.
Clear Choice dental implants gave me the ability to take on the world. I feel so much better, and I think that that is the key.
Introducing SimpliSafe's new wireless outdoor security camera. It works with SimpliSafe's already award-winning system. It's like adding an extra layer of home protection. Get it? Extra layer.
Award-winning home security just got better. SimpliSafe.
Let us take a sightseeing tour.
The French Dispatch is a rocket ship ride to your cinematic soul.
Physically or metaphorically?
Both. It's Wes Anderson's most innovative and beautiful movie yet.
No, it isn't. Yes, it is. No, it isn't. Yes.
The French Dispatch, rated R.
Everyone remembers the moment they heard, "You have cancer," how their world stopped, and when they found a way to face it. For some, this is where their Keytruda story begins. Keytruda, a breakthrough immunotherapy that may treat certain cancers. One of those cancers is advanced non-squamous non-small cell lung cancer, where Keytruda is approved to be used with certain chemotherapies as your first treatment if you do not have an abnormal EGFR or ALK gene.
Keytruda helps your immune system fight cancer, but can also cause your immune system to attack healthy parts of your body. This can happen during or after treatment and may be severe and lead to death. See your doctor right away if you have cough, shortness of breath, chest pain, diarrhea, severe stomach pain or tenderness, severe nausea or vomiting, headache, light sensitivity, eye problems, irregular heartbeat, extreme tiredness, constipation, dizziness or fainting, changes in appetite, thirst or urine, confusion or memory problems, muscle pain or weakness, fever, rash, itching or flushing. These are not all the possible side effects. Tell your doctor about all your medical conditions, including immune system problems, or if you've had an organ transplant, had or plan to have a stem cell transplant, or have had radiation to your chest area or a nervous system condition.
Today, Keytruda is FDA approved to treat 16 types of advanced cancer and is being studied in hundreds of clinical trials, exploring ways to treat even more types of cancer. It's true. Keytruda from Merck. See the different types of cancer Keytruda is approved to treat at Keytruda.com and ask your doctor if Keytruda can be part of your story.
The new rule, if you're over 45, colon cancer screening. With the Everlywell Fit colon cancer screening test, you can practice preventative care, all for only $49. Screen at home and get your results in days.
84% of people have subscriptions they've forgotten about. Truebill helps you save money.
by finding recurring charges, notifying you when they're due, and easily canceling unwanted subscriptions. Download Truebill and take control of your money.
Guys, as we get older, we all lose testosterone. Force Factor's Test X180 works to boost it back, build muscle, increase energy, fuel desire, and improve performance. Rush to Walmart for Test X180, the #1 fastest growing testosterone brand in America.
These folks don't have time to go to the post office. They use Stamps.com. All the services of the post office, only cheaper. Get a 4-week trial plus postage and a digital scale. Go to Stamps.com/try and never go to the post office again.
We have known for a while now that former President Donald Trump has been trying to prevent the investigation into the attack on January 6th from getting access to his White House records. But until now, we did not know what exactly he is trying to keep from that investigation. Now we know, newly, that it turns out it's a lot that he's trying to keep from that investigation. And it sounds like it's crazy town stuff. This is something that we learned this weekend in a late night court filing from the National Archives. National Archives is in charge of all the White House records from previous administrations, including the Trump administration. This weekend, the National Archives submitted a big, long filing late at night, like after midnight on Friday night, about what Trump is trying to keep secret and keep away from that investigation. And there's 3 different things that it taught us. First of all, there's just the amount of stuff that Trump is trying to keep away from the investigation. There's like 1,600 pages of records that the archives have so far identified as being relevant and responsive to the committee's investigation and to their requests for documents. Trump is claiming that of those 1,600 pages, nearly half of them should be shielded by executive privilege. And that includes his daily schedules, his appointment logs, even the logs showing who called the president on and around on January 6th, speech drafts from him, correspondence, handwritten notes about the events of that day. He says that's all shielded by privilege. To be clear, the current president has already said none of that is covered by executive privilege. That should all be handed over to the committee. And that's the second thing to know about this new court filing, that the archives themselves, the National Archives and Records Administration, they just tear apart Trump's claims that this stuff should be kept secret. The archive says, first of all, it's only the sitting president who gets to decide what's covered by executive privilege. The sitting president is Joe Biden, not Donald Trump. President Biden has already said this stuff is not covered by privilege, therefore it's not covered by privilege. The archives also says that even if Trump did have some kind of right to claim executive privilege, it would obviously be outweighed by, quote, Congress's compelling need for information about the extraordinary attack that occurred on the Capitol. So number 1, Trump is asking for a ton of stuff to be kept secret. Number 2, he's saying it should be kept secret on the basis of privilege. And everybody involved is like, yeah, dude, no, you don't even get to say that. And if you did, we'd still say no. But here's the third and most interesting thing we learned this weekend in this filing. In this court filing, the National Archives actually describes some of the specific records that Donald Trump is trying to keep hidden. And that's that list of, logs and speech drafts and correspondence and stuff like I said. But also there's this, quote, a document containing presidential findings concerning the security of the 2020 election after it occurred and ordering various actions. Sorry? What were these presidential findings about the security of the election? And what actions was Trump prepared to order on the basis of those presidential findings? Did he try that? What were his findings? Did he try to order something in response to him finding something out about the election security in 2020? What? Also, there's this, a quote, draft executive order concerning election integrity. Trump drafted an executive order about election integrity in 2020? Again, seems like something that would be important for the January 6th investigation to have if we're going to understand the full scope of what former President Trump and his advisors were planning or attempting in terms of overturning the election. We are going to need to know what kind of executive order concerning election integrity the White House had drafted, let alone his presidential findings and actions in response to them that he had apparently written up and now wants to be kept secret. As far as I know, we'd never known about either of these things before. I'm very interested to find out what they are. There's going to be a hearing Thursday before a federal judge on Trump's lawsuit to try to block all this stuff from coming out. The National Archives says they're going to release all these records to the January 6th investigation at the end of next week, unless the court orders them not to. Whew. Watch this space.
What?
A document can't spin what it says. 187 minutes. The former president watched these scenes, but did nothing. This comes as the Washington Post reports incredible new details about that day and the numerous people who saw the violence coming. How? It was just spontaneous, right? Just a couple of kooks online talking about it, but they never expected they'd be that successful, right? Right? Donnell Harvin, the head of intelligence at D.C.'s Homeland Security Office, not only notified multiple agencies about the violent chatter online 2 days before the attack, but he also alerted the city's health department to call up D.C. area hospitals to prepare for a mass casualty event. Empty your emergency rooms, he said. Stock up your blood banks. Donnell Harvin joins me now. It's good to see you, sir.
Thank you, sir.
What did you know?
Well, it's not what we knew, it's the threat picture that we had seen. And so leading up to January 6th, we started seeing a lot of concerning information surrounding the events that were planned. Information from particular actors that we hadn't seen before, specifically looking at what we call TTPs, tactics, techniques, and procedures, that indicated that they would be intent on performing acts of violence, interpersonal violence, and possibly even smuggling weapons into the district.
So how come we weren't more prepared?
Well, you know, like you and other Americans, I'm looking forward to seeing the conclusion of multiple investigations into that. I can't speak to why what happened at the Capitol actually happened. Our job, from my team's standpoint, was to collect, analyze, and disseminate threat information to as many people as possible. And that's the role of the Fusion Center. That's exactly what we did.
So first, let's get a sense of what it was, and then we'll get to what it meant to you. When you look at what you were seeing, do you believe that this was about disparate sets of groups that were just equally pissed off about things? Or do you believe there was coordination of intent and purpose?
I think it's a little bit of everything. So what we found, even leading up to the January 6th, what made us really concerned was we saw a core group or several groups of individuals that were well organized and had articulated specific, as I mentioned before, tactics, techniques, and procedures that would bring to bear a lot of violence, in our estimation, if they came to the District of Columbia. Using a large amount of people who were there for their First Amendment protected activities as shields or even as a force multiplier for their more nefarious activities.
So do you believe that what happened on that day was just a chain of things that couldn't have been anticipated, that, you know, well, the guards kind of let them go because there was too many of them and the Capitol Police weren't set up for it, and people started to enter the Capitol, but it was benign at first, but there were just some bad actors? Or do you think it was more intentional than that?
Well, I'll be honest with you, everyone's focusing on January 6th, Chris, but the seeds of what happened on January 6th were planted a long time ago, and we've seen this fomenting in American society well before January 6th. And I know everyone's focused on January 6th, and there'll be an autopsy, and it's ongoing right now. But while that autopsy is occurring, we can't lose sight of the fact that the elements that made January 6th possible are still there in our society. Even after January 6th, we started seeing threat information for individuals who didn't go to D.C., who lamented that they hadn't been here, and had articulated
For financial advice here, I am singularly unqualified to offer that kind of advice. If anybody ever tells you they've received financial advice from me, run and get back anything they owe you. But still, even me, even unqualified me, can spot a red flag this big and this red. As you might recall, within the last couple of weeks, the former president announced a new commercial venture. that was seeking public investors, the Trump Media and Technology Group. This newly announced venture said it would include a social media platform called Truth Social. And with the announcement of the new venture, they invited everybody to download the app. Within a few hours, people had found a test version of this online that appeared to be operable, and they registered what appeared to be the official Truth Social Donald J. Trump account, and then promptly had that account post a picture to the platform of a pig going to the bathroom. And pigs don't use bathrooms. Washington Post reporter also found that it was possible to register what appeared to be an official account in the name of Mike Pence. The Post also revealed that the platform runs on completely free open source software that literally anybody can download online to make their own social networking site. So things haven't exactly been off to a real proprietary, impressive gangbuster sort of start. But as Forbes points out today, the new company is also making unusual contingency plans when it comes to how its business is going to go in the years to come. In what would usually be a fairly boilerplate, boring filing with the Securities and Exchange Commission, this public company that's going to acquire Trump's new media company, they outlined what would happen if a, quote, material disruptive event were to occur in this new venture. Quote, in order to maximize business continuity and to minimize, mitigate, or eliminate any negative impacts on the company from a material disruptive event, the company principal's ownership shall be structured in such a way as to eliminate the need for restructuring of ownership were a material disruptive event to occur. Now, the company principal here is Donald Trump, and the definition of a material disruptive event is this, quote, a material disruptive event means the occurrence of any of the following after the closing. Number one, the company principal, Trump, announces that he is running for a public office. Or number two, the company principal, Trump, is personally convicted of a felony criminal offense. I'm just saying, to the extent there are red flags visible from a mile or so, the company is preparing for anything. Trump 2024, we factored that in. Trump getting personally convicted of a criminal felony from one of the several ongoing investigations he's facing, we've baked that into the cake. Read the fine print very, very carefully on Trump's new ventures. We'll be right back.
critical race theory in an effort to re-engineer attitudes and belief systems. And by the way, that's not all. In 2019, the state superintendent circulated a memo to school districts that explicitly championed CRT as an important analytic tool in the field of education. Now, as we speak, the Virginia Education Department promotes CRT on its website. One page extols the virtues of anti-racism in education, stating, anti-racism requires acknowledging that racist beliefs and structures are pervasive in education and then actively doing work to tear down those beliefs and structures. And even someone who should know a heck of a lot better, like UVA professor Larry Sabato, mischaracterizes the views of Virginia parents who've led the revolt against McAuliffe and the whole anti-racism curriculum.
The operative word is not critical, and it's not theory. It's race. There's a lot of, we can call it white backlash, white resistance, whatever you want to call it. It has to do with race. It's this generalized attitude that whites are being put upon, and we've got to do something about it, we being white voters.
Wait, a generalized attitude? What? Has he not been watching Loudoun County? Rapes covered up, a victim's father thrown to the ground, and my personal favorite, the diversity and equity fraudsters trying to end advanced courses for gifted and talented students. Now, these are very specific and legitimate concerns parents have about the issues that directly affect the lives of their children. And as far as this being a white thing, since when is quality education a white thing, Larry? One of the most outspoken voices against the far-left agenda would beg to differ.
I fit into the intersectional world. I'm a Muslim, I'm an immigrant, I'm a mom of color, I am a single mom, but yet I deny all of these, privileges in the new paradigm of the oppression matrix because we're all human beings. And that's what we need to teach our children.
You get it? Officially a white thing, right? Well, instead of being stuck on the defensive, Glenn Youngkin has smartly focused his campaign on bread and butter issues, the issues that transcend party affiliation. Now, most parents want the schools they fund to work for them, and of course for their children, not against them. Democrats misread the results of the 2020 presidential election. It's obvious tonight. Bernie Sanders did not win the Democrat nomination. Joe Biden did. Biden essentially had a mandate to end COVID. That's about it. His far-left base wanted much more, however, and he was too weak to resist them, as we told you he would be. And so was McAuliffe, who mistakenly thought he could glide to victory on anti-Trump fumes in January 6th. And this is a recipe for failure not only in politics, but in the media as well. January 6th is their drug of choice, and every day is an overdose.
This is so encapsulates the whole problem. Everyone with a scrap of honor in them was scared bleepless of getting fired and replaced by a real coup planner, plotter, carry-outer.
The Washington, D.C. Intelligence Fusion Center actually suggested to area hospitals that they stock up their blood banks. We actually permitted an insurrection that would have taken down our democracy.
Why isn't Merrick Garland screaming about this every single day? Why isn't the president screaming about this every single day? There's nothing right now to keep Josh Hawley from, taking the chains off the back door and letting people sneak in like a high school shooter.
I mean, this is so pathetic. It's so backward looking. And no one is listening to them. Probably got more people watching just then than they did during the day. Now, the Democrat Party under Biden has gone so far left, it's left America, and even managed to turn off very blue elements in very blue Northern Virginia. Think about it. So much of the success of the Democratic Party in the past 4 years was in the suburban female vote. As usual, Democrats took them for granted, including Terry McAuliffe. Somehow they thought they could run to the left on education, on race, on taxes, the economy, immigration, and still keep a lock on women voters. Tomorrow will show you they were very wrong. The one group the Democrats could not afford to alienate, they have succeeded in alienating. On election night 2020, when so many people were demoralized and down, I reminded you that the Trump policies worked spectacularly. we needed to do at the time, what we needed to do was stick with them. I think when we look at Florida and focusing on the GOP for a moment, Martha and Brett, the coalition that the Republicans have been able to put together in that state is really something that they should try to replicate as much as possible going forward. The other story, which I think you're seeing playing out in state after state tonight, is that Trump brought more people into the party and then expanded the base from those blue-collar workers on out. Yes, Ron DeSantis is governing on that same populist agenda that was so successful before COVID hit during the Trump years. It's a model for the rest of the nation, and Glenn Youngkin is smart enough to see this. Just like he had to campaign in every county in Virginia, Republicans in 2024 will have to fight in every state. Yes, that means a 50-state strategy. The polling is showing us that America has already had enough. 71% say the country's on the wrong track. That's horrible for Biden. His RCP average for job approval is just 43%. And Republicans are holding an 18-point lead over Democrats on fixing the economy in the latest NBC News poll. In other words, America now sees that if we go woke, we're going to go broke. Today, only 35% say the economy is doing well. 65% say it's doing poorly. So the lessons from Virginia and Florida are clear. Trump showed us that pragmatic, populist, pro-American worker policies in education, the economy, and immigration work incredibly well. And these populist policies work everywhere they're tried. But the Democrat socialist approach fails everywhere it is tried. Heck, it's been crashing and burning in urban America for decades. Without safety, without decent schools, with soaring inflation, what do our citizens have to look forward to? A hellscape, I guess. And all these efforts to stir up racial tensions, it's just not working. Yeah, people are sick of it, all right, but it's also wicked and it's evil. It's evil when the Lincoln Project does it. It's evil when political analysts do it. It's evil when Biden does it, and when Stacey Abrams tries it, and when McAuliffe does it, as he did late today. Biden's 10 months in office remind us in stark and painful terms of Democrats' failure across the board. This failure continued today in Scotland, where climate control freaks who only fly private lectured the rest of the world about sacrificing their standard of living. Of course, Biden falls right in line, leaving us essentially unrepresented across the Atlantic. When they wake Biden up to tell him his friend Terry is flaming out in the Commonwealth, will he understand the significance of it all? Will he question his decision to cave to the far left at every turn? I wouldn't count on it. But you will. And that's the angle. Joining me now is Tom Bevan, president and co-founder of Real Clear Politics. Tom, the Democrats have gone all in, playing the race card in Virginia right up to the last moment. As you have noted, that kind of politics, at least now, is seeing diminishing returns. Has that calculus changed?
No, I mean, McAuliffe has made this all about this campaign, all about Trump. And on the education issue, instead of walking back his mistake that he made in that debate, he's doubled down and tripled down on it, and then turned around and said that Glenn Youngkin is using a racist dog whistle. Now, they brought in Barack Obama, Kamala Harris, Stacey Abrams to try and activate the black vote in Virginia, which Terry McAuliffe got 90% of the black vote when he ran the first time around. The latest Fox poll has him at 80%. Glenn Youngkin's winning 14% in that poll. So McAuliffe really needs to get closer to that 90%. And the other reason that they're using this tactic is to try and win back some ground among white women in the suburbs, in the Northern Virginia suburbs, where they have lost ground on the education issue. And that is the beating heart of the Democratic coalition. Without suburban women and without African-American voters, women in particular, Terry McAuliffe is not going to win this race tomorrow.
According to CNN's Jeff Zeleny, McAuliffe is really down, Tom, because Biden's massive spending bills just haven't passed yet.
There's no doubt that President Biden's lower approval rating here now in the Commonwealth and indeed elsewhere is contributing to this sense of malaise among Democrats. Unable to pass an infrastructure bill, unable to pass a broader reconciliation bill of those social safety net programs. So it definitely has contributed to really a lack of positivity about the direction of the country.
Tom, have you seen evidence that Biden's agenda is actually hurting Democrats in Virginia and elsewhere?
Well, certainly when the president's job approval rating is at 43% in Virginia, it's not helpful to Democrats. I mean, McAuliffe has two problems, right? He's got the education issue, which has exploded and become really a movement, again, in those critical Northern Virginia suburbs. But the Biden agenda is also, I mean, this recent Fox poll that came out said that 60+% of people think that even if those two bills, the two massive spending bills, are passed, that they're either going to not have any effect on the economy or make things worse. And so this idea that passing those bills is somehow the cure-all for Democrats, I don't think the data supports that. So, but certainly the fact that the Democrats have been squabbling and unable to get on the page, it has contributed to this idea that the Democrats are divided, they're deflated, and McAuliffe is getting no help from Washington and no help from the president.
Oh, it's almost like Joe Manchin over there in West Virginia is kind of waiting to see how this all plays out in Virginia, or is that just a kind of a goofy analysis? But he was talking about the budget gimmicks today and seemed quite exasperated about what the progressives are trying to pull in this spending bill, Tom. As, by the way, Youngkin is about to take the stage.
Yeah, I mean, Manchin really sort of blew things up. But also, I mean, given, his past history on this, I think he wants to get the hard infrastructure bill passed. And then we'll see what he does on the other bill. I mean, I think Democrats were very unhappy with what he did and how he did it, the timing in which he made his announcement today.
Tom, great to see you. Thanks so much.
Thanks.
And as you see, there is Glenn Youngkin. That's the final push. And he's going to be taking the stage any moment. We will go to it, perhaps, in the next couple of minutes. He's doing that dancing thing. There it is. Let's watch it. We told him not to dance. Didn't Raymond tell them that? But that's all right. He gets a huge crowd there. He has over 3,500 people there. I guess now it's almost up to 5,000, according to our friends on the ground. And who's a better dancer at this point? Is it Terry McAuliffe or Glenn Youngkin? Well, neither are going to be on Dancing in the Stars, but the energy and emotion clearly with Glenn Youngkin at this point. We were driving through Northern Virginia earlier tonight, and parents and kids are kind of on their way to sports practice, coming back to sports practice. They were just having these like spontaneous little rallies, and they were just popping up and, waving at people. They seemed to be getting a lot of positive response, and, well, including from this host, but we were waving at the crowd there. Now, we're going to move on. We'll go back to the Youngkin rally in a moment when he starts talking. But let's go to Chris Rufo here, because contrary to what the Democrats would have you believe, critical race theory is being taught in Virginia. It's also being pushed in corporate America. In fact, AT&T has created a racial re-education program that promotes toxic ideas, including that American racism is a uniquely white trait. One senior employee tells journalist Rufo that white employees are expected to confess their white privilege under a threat of negative performance reviews. That same source also says employees are pressured into signing a loyalty pledge to keep pushing for change by reading more about systemic racism and challenging others' language that is hateful. Chris Rufo, Manhattan Institute senior fellow, contributing editor at City Journal, joins me now. Chris, Glenn Youngkin's about to take the stage and start speaking, I should say, in Leesburg, Virginia, in a rockin' rally. Critical race theory, a huge issue in Virginia. They tried to wish it away, but of course it is being taught in Virginia and now at big major corporations across the United States. Give us the bombshell.
Yeah, that's right. I mean, critical race theory is becoming the default ideology of the professional managerial class. It's absolutely taught in Virginia. In fact, Terry McAuliffe promoted critical race theory to all public schools when he was last governor in 2015. And we see it even at a place like AT&T, that on the front page of their internal critical race theory training program, they told white employees, quote, "White people, you are the problem." This is the kind of degrading, dehumanizing, and race essentialist rhetoric that has no place in our corporations, in our schools, but the elite people of our country, people like Terry McAuliffe, people like Randy Weingarten, the teachers union president, and even the CEO of a great company like AT&T, maybe a formerly great company. It is all the rage, and it's up to us to expose it and to stop it. I hope that people that are voting in Virginia get out for Glenn Youngkin. It's time to say no to race essentialism in our schools.
And Chris, a lot of the work you've done to expose this, it's coming to light all across the country. We're going to dip in. Stick around, though. We're going to dip in, hear what Glenn Youngkin's saying in his closing remarks in this campaign.
be a commonwealth of low expectations. We will be a commonwealth of high expectations. Friends, this is our moment where we stand up for our children, for our grandchildren, for our nieces, for our nephews, for our neighbors, and we decide that we, in fact, are going to be in charge of our children's education. We know that in order to do this, we have to break the power out of Richmond. We have to have a moment where power shifts away from the marble halls in Richmond and it moves to the kitchen tables around Virginia. Kitchen tables that are bound together by freedom and liberty. But these kitchen tables, sometimes that discussion happens over breakfast after a midnight shift, where we're talking about those issues that are most important to us. Those issues that are going to define the future of this Commonwealth. Those issues that we as Virginians share as values. From the farms in the Shenandoah to the docks in Newport News, to literally to the monuments in Arlington Cemetery, to the banks of the James River, to the school board meetings in Loudoun County. This is where parents are. This is where Virginians are, where we come together to redefine this future. Folks, this stopped being a campaign a long time ago, and it started being a movement led by all of you, led by you. And as we head to the polls tomorrow, we have to remind ourselves that this Virginia that we know we can build together, this Virginia that is the promise that we have held out for our children and our grandchildren, this promise of Virginia where we can in fact see our kids dream the biggest dreams they can think of and go get them. This Virginia where our parents and our grandparents go for a walk and the only thing they worry about is what they're going to do tomorrow because today was so great. This Virginia where our children can be college ready or career ready. This Virginia where in fact you have more of your money in your pocket versus in Terry McAuliffe's pocket. This is the Virginia promise that we can build together, but that promise hangs in the balance. It hangs in the balance because tomorrow we must go get it. It will not be given to us. This democracy is not a spectator sport. It is an active involvement. We must go get it. We must go get it. And so we find ourselves tonight thinking about what can happen tomorrow. And what can happen tomorrow will be a statement that will be heard across this country. Because America needs us to vote tomorrow as well. America's watching. Why? Why? Because all across this country, families are having the same discussions that you all have. I get notes all day long. Glenn, stand up for our kids too. Stand up for the rights of our children because we can't vote this year. You in Virginia do. We have problems in our school boards. We have problems in our schools. Stand up for us, Virginia. Well, let me tell you, Virginia is going to stand up for them tomorrow. That's what we're going to do. USA, 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 USA. Friends, do you know what's at stake? We do. The future of this Commonwealth, the future of this country is going to be decided tomorrow. Our nation's history is our Commonwealth's history. And our nation's future is going to be determined by the present. How we vote tomorrow will make such a statement for families around this great country to have hope, to recognize that, yes, the values that we hold dear, the values that underpin this country are still alive and well, and we can put them into action tomorrow. So here we go. Here we go tomorrow, folks. What we need to do tomorrow is show up and vote. We need to show up and vote because nothing happens unless we fully engage. And then when we fully engage, let me tell you what's going to happen tomorrow. We are going to sweep our statewide offices tomorrow. Sweep them. And we are going to elect Jason Miyares as our next Attorney General. And let me tell you, if Attorney General Mark Herring won't investigate the Loudoun County School Board, Jason Miyares will. And we are going to elect Winsome Sears, our next Lieutenant Governor. And we are going to sweep into office a brand new majority in our House of Delegates. But we're also going to win local office.
And wow, Glenn Youngkin on fire on the education issue and beyond in his closing argument for the Commonwealth and for the Virginia governorship. Again, I've lived in Virginia for on and off for 25 years, and I have not seen that type of energy in a long, long time. Chris Rufo, you're still with us. You're watching this unfold. This is a bellwether, perhaps, for how things are going to go in the midterm elections, if indeed Glenn Youngkin pulls out this victory, which is now expected by many.
Yeah, that's right. And Terry McAuliffe has presented a really grim vision of faceless bureaucrats and school administrators forcing critical race theory on kids, telling that they're inherently oppressive, and then covering up for sexual predators in schools like we've seen in Loudoun County. While Glenn Youngkin is presenting a hopeful, optimistic vision, he trusts American families, he trusts American parents. He wants to put more power and authority back in individual people. He wants to liberate students and inspire them to achieve academic excellence. The choice to me is clear, and I hope that the Virginia voters see what's happening. They get around the obfuscation and the lies that have emanated from the Terry McAuliffe campaign, and they embrace their destiny and their future, which I think Youngkin so beautifully laid out tonight. So to all of you in Virginia, make the best choice. Get out to vote.
Chris, thank you, and also for that reporting on AT&T. We really appreciate it.
You can't force someone to have medical treatment that they don't want to have. It's a violation of human rights.
I would tell all of our politicians, stop playing politics with our lives and stick to the science.
It's coming from the same group that claims to help us the most, that supports us the most, is the Democrats. And they're enforcing something that they know people of color have rightful, we're worried about the outcome.
The firehouse near my house is closed, it's out of service. 26 firehouses are affected, 26. And for de Blasio to say that, it's not affected, he's a liar. He's a liar.
When we go to calls, we don't look at that person and judge, are you worth saving? But now our livelihoods and our families' well-being is questioned, are we worth it? And we never asked that question during the pandemic, but now we're being thrown into the trash like garbage. It's not right.
So this city and the politicians that run this city have decided to divide us. They want us fighting each other because they don't want us to find out that they're the ones that did this.
New York City anti-vaccine mandate protesters today, but they're not the only ones out there opposed to vaccine mandates. A new NBC poll found that 50% of Americans oppose them, with 41% strongly opposed. Among them are many New York City firefighters. In fact, more than 2,300 have called in sick over the past week ahead of the city's vaccine mandate going into effect today. Joining me now is Andrew Ansborough, president of the Uniformed Firefighters Association. Andrew, is the city going to work with the union, or are they intent on ignoring you and allowing all of these firefighters basically to be forced off the job?
Well, by design, they don't want to work with us. When you tell someone they have 9 days to make the decision for vaccination or lose their job, they don't want to work with you. Teachers were given over a month. Corrections doesn't have to make this decision until December 1st. So once again, the mayor is showing that people that care for criminals have more rights than people that care for the average New Yorker.
Now, I would just like to go back to the notion that 2,300 firefighters have gone out sick over this. The department doesn't share their numbers with us, but the commissioner of the department actually said today that he believes there's a sick out and it's vaccine related, and the vast majority of the firefighters that are out sick are unvaccinated. You can't claim that the unvaccinated firefighters are causing a staffage shortage, because this morning you were sending them home. So they wouldn't have been working either way. Now, it's no secret that New York City firefighters love their jobs. They continue to work hurt. And when those firefighters, we believe, were faced with the possibility of losing their jobs, they wanted to document those injuries before they went out the door. He's also not taking into account, those numbers are skewed by the fact that we have firefighters that are always sick and injured from firefighter-related duties. Even before that, before this vaccine mandate started, we had 16 firefighters out on medical leave, firefighting-related medical leave, for every one firefighter out on COVID leave. 1/2 of 1% of the fire department was out with COVID.
Well, there's some good news today out of Cook County in Chicago. Breaking late today, a Cook County judge granted the Fraternal Order of Police's petition for a stay of the COVID vaccine mandate there. Does that give you some hope if there is a legal avenue here?
You know, there are people that claim that we're anti-vaccine. I was vaccinated the first day, and I educated my members to the best of my ability as to the vaccine. But from the very beginning, there were a lot of my members that felt they didn't need it because they were already infected previously. Now, what came out of Cook County today does bring us hope. We are counting on the lawsuits here. We're not anti-vaccine. We're anti-mandate. And we just want our day in court. 9 days to go from the announcement to compliance doesn't give you enough time to have your day in court. We just want our day in court. And we want to have the ability to be heard.
This is going to backfire on de Blasio, just like so many of his other policies, from defund the police to all the issues that have cropped up with law and order. It's all spectacularly backfiring. But the firefighters who have been through so much deserve a heck of a lot better than this. Thank you for advocating for them, Andrew. Good to see you tonight. Keep us up to date. And dinosaurs crash into the UN climate conference, and Biden gets a cold reception in Glasgow and in the air. Raymond Arroyo has the details, seen and unseen, next. When did the California dream turn into a nightmare?
These are some third world country type conditions.
The homelessness with no end in sight.
They allow our city to be a dumping ground. The entire nation's homeless.
The drugs.
More people died last year of fentanyl overdoses than they did of the COVID virus.
The dangers citizens are facing every single day.
The primary purpose is to lower crime in this area by building those relationships with everyone.
We get to the real truth behind it all. California on the Edge with Laura Ingraham. Streaming now only on Fox Nation. Sign up today.
Get a free mesothelioma book from mesobook.com.
People who have been diagnosed with mesothelioma have many questions. That's why we offer this free book.
Call toll-free at 1-800-400-9216. To make progress, we must keep taking steps forward. We believe the future of energy is lower carbon, and to get there, the world needs to reduce global emissions. At Chevron, we're taking action, tying our executives' pay to lowering the carbon emissions intensity of our operations. It's tempting to see how far we've come, but it's only human to know how far we have to go.
Training our bodies helps our minds. To go after the moments which develop us into who we are.
By the time you're done reading my book, you will believe that with God, all things are possible. And to thank all of you for your support, I'm offering some of the best prices ever on MyPillow products, including this exclusive bundle. You get my book and these 3 MyPillows. You get the Statue of Liberty, you get the American flag, and you get with God, all things are possible. Regularly just $134, now it's just $49.98 with your promo code and free shipping. So go to mypillow.com/USA and use the promo code on your screen or call the 1-800 number below to receive this exclusive offer. Thank you and God bless.
Guys, all of these prostate formulas claim to reduce your urges to urinate, but only one is also the most recommended brand by